Kohberger allegedly stalked one of the victims. That's false. You knew that was false. For anybody who had never heard that before, that question is now planted into them, unqualified representation that Mr. Kohberger stalked one of the witnesses, and that's false. We do not have evidence that the defendant had direct contact with 1122 or with residents of 1122, but we can put his phone in that area. There are many residences in that area. It's a dense population of mostly college-related occupants.
Everything stated in this video is my opinion and my opinion only. And just like everything else in these cases we discuss here on this channel, everything is alleged. Hey guys, I was not expecting documents. That is for sure. I was not expecting documents. I actually had planned for us to go over an interview that was done, I believe it was back in October of 2025. Do you guys remember when we went over the interview of a girl that was in Bryan Kohberger's class and it was on like an Apple podcast like a long time ago? That exact same Apple podcast also interviewed Detective Powell from the Idaho State Police like a super long time ago. And I've had it like edited down and ready for us to go over for like a super long time. But then all the interviews and stuff started coming out. And so it just always got pushed back. We were going to go over that tonight because I just kind of wanted something that I didn't have to think too much about. Because I told you guys we were going to go ahead and go live tonight because I'd spent the last couple of days basically taking the boys all over the place. So we're going to play games and stuff later tonight, but I could go live tonight and it not be a big deal. So we were just going to relax, listen to this interview, and see what he had to say, because Detective Powell is someone that was there at the scene and collected evidence. I've had this thing again for months and I have not listened to it. I listened to it enough to go in and like cut out the ads, which is I'm just like skipping through. And once the music starts and the ads play, I go and I take out what I need to take out. And then I that's it. I don't know what he has to say, but I've been wanting to freaking listen to it. And you know, the second I try to relax a little bit. Okay. So documents everywhere. I went in and grabbed all of these and placed them in the Google Drive. So let me show y'all what that looks like real quick. Right here we have the folder for all of the court records. And then when it comes to 2025, I have it split. Now, my internet has been acting up like a super lot. So if this is laggy, then it's probably because my internet's been acting really, really bad. Like we got our game and stuff downloaded. I thought that maybe after that it would stop, and it hasn't stopped. But I also unplugged it on accident earlier when I was cleaning and like mopping and stuff underneath my desk. So it's probably my fault. Probably my fault that it's been a little slow. It's probably my fault. So we'll see. We'll see how this works out. Okay. So this is the folder. And which one is this one? This is pre. Okay. This is the pre. Wrong. Go back. What is going on here? Hold on a second. Is it this one? What is going on with this? 2025. Yeah. I literally did this earlier today. What is happening? I am very confused. I am very confused. I guess this is them right here, and I have them in the wrong. What folder is this? Pre-guilty plea. Okay, no, this is the right folder. Oh my God. Okay, no, this is the right folder. Okay. One thing I want to show you guys real quick before we get started is about the WSU lawsuit. Sarah found, here it is right here. Sarah found that there was a protective order that has already been ruled on before the hearing that we have coming up on June the 1st. So there was like 3 files that were posted that I plan to go over this weekend. And in one of them, which I find so ironic, okay, in one of them was this protective order that both the parties, the families, including Steve, okay, and that's where I'm going to argue the irony here in a minute, the families and WSU, like together from how it reads, the parties, both parties, wanted this protective order over things, the same way that there was a freaking gag order in this case. And I just find it freaking ironic because Steve and them fought the gag order in court in front of the judges, both judges. Like, they didn't want anything. They didn't want the gag order. They didn't want the protective order. So they instantly wanted one here. And I'm just like, wow, really? That's crazy. Well, it's been denied. It has been denied. It's not going to have a protective order. And they didn't wait till June 1st when there's a Zoom audio hearing in order to rule on it. They instantly were like, no PO. So let me link you guys to Sarah's Twitter account real quick. And we're going to go over all of the documents on a live this weekend because the hearing is on Monday. So the way that it was like last time, we went over everything the Sunday night and then there was a hearing on Monday. This is not going to be, whatchamacallit, visual. Like, we're not going to be able to see their faces or anything on this one. It's audio only. So I don't really know how that's going to be. I've never been in one that looks like that. So we'll definitely be taking a look at it on Monday. But on Sunday at some point, we'll go live and look over all the documentation. Okay, so this is the new case of interest website. Sarah brought it to our attention the other day that they had done like an overhaul update on it. It is very different, but there is no longer a case summary. So you guys know how like we have the documents separately like this, right? But then we have a case summary where it would be like, I don't know, it got to like 50 or 70-ish, somewhere around their pages. And it was just like a list of everything. And that's sort of how we knew like a day or so ahead of time that something might be becoming public that we needed to watch for us to be able to go over. Well, they got rid of that, which sucks. They got rid of that, but they still, thankfully, have a new in red that goes next to the new ones that were unsealed. And it starts all the way down here. Now, this section of these documents were the ones from a long time ago that were taken back. The ones that had all of the unredacted forensic reports. The ones that had Jack DeCore as suspect number 1, the one that had people's social security numbers and stuff in it that shouldn't have been in it. Those ones, which have been right here. Now, I wasn't able to grab all of these the first time around before they removed them. So Sarah actually had them and we were able to go ahead and get them over here. But if you go through and open them yourselves, they're all the exact same thing. They're all the exact same ones that we got before. Now, I don't know if there's any differences. I'm just saying they're the exact same file. The exact same file. Now, I will also remind you that when it comes to the Google Drive and those forensic records, that I also went in and separated those out so that you can see the unredacted ones next to the redacted ones. So there'll be one that's redacted. Obviously, as you can see, that some of these still have the black markings and stuff on them. But then there next to it, if it's got a doubled number, it will be the unredacted one. There's still a few of them that we do not have an unredacted report for. A few of them. There's also an index that I created for this folder right here with a screenshot of the very front page, just so that you guys can see exactly what it is in this report so that you can go right to the one that you need instead of having to open all of them up and try to figure it out. Because that's what was stopping me from being able to really look at a lot of stuff. And I just realized this has to be, this has to get more freaking organized. And again, we're still missing a few. So I do plan on going in and looking at these again. I mean, I went through them again today because I did go in and grab all the rest of them and then add them to the file. But I didn't see that anything was different in there at all. So I don't feel like the ones that we're missing are in that because they all have the same amount of page numbers and everything else. So we still have a few missing. Now, when it comes to the newer stuff that got released, let's see. This is Exhibit S1, a state's response to defendant's 7th motion to compel, but I feel like we probably need to start down here because there's some responses to things and I don't want to do it backwards. So let me hold on, let me go back and open this folder. Okay, so when it comes to this folder, and I'll share it one more time, these ones right here, not in the folders, but these right here are all the ones that did post today. Because I know that some of you guys can't actually access the website. So there's the Google Drive link. It should just let you straight up open it. Hey, Sprinkle Love, thank you for being a member for 3 months. Thank you. I hope you had a great day too. It's Friday. I'm just glad it's Friday. 15 months, Teresa. Thank you. I appreciate you being here. I was really hoping to listen to that interview just because he's the evidence guy. And I finally was like, oh yeah, I keep forgetting that it's in there. It's been over there on my storage channel that I use for everything for literal months and months, and since literally 2025. Somebody commented about it over here a long time ago, and I went and grabbed it, and it's just been pushed back. But you know what? We'll get to it. We'll get to it eventually. Okay, so we already know that they wanted to not mention the 2014 cell phone incident at trial. And again, I find it interesting that the things that could maybe show like a ramp up or, anything that could maybe point him in like a bad light, you'd think that the state would have wanted to use, right? So I just found it interesting that the state agreed to this, even though the cops were called and everything else for the situation where he sold his sister's phone. I think it was what was it, like a mall kiosk or something like that? Like one of those little machines or whatever. So we know how that already went. They already agreed to it. So I don't know if this is anything different. This looks like the same stuff that we've already known. Comes now Bryan C. Kohberger by and through his attorneys of record in the Latell County Prosecuting Attorney's Office, and hereby provides this honorable court a stipulated agreement between the parties to not mention anything during trial regarding a 2014 cell phone incident where Mr. Kohberger took his sister's cell phone. Yeah, this is something that we've definitely already known about. There wasn't anything new in it. Okay, so then we have this motion in limine for inconclusive data. Was this the one about the inconclusive from Maddie's fingernail clippings? Is this the one? Because remember the state tried to say that them saying that it was inconclusive was doing Kohberger a favor or something like that. And we were like, no, you're not, because it's not giving an answer. It's just putting its name in there when it's really not necessary because it's not anything. That's also what's so crazy. So when it came to those fingernail clippings for Maddie's left hand, the defense team had no issue taking that and pushing that for further testing to get their actual answer that made Kohberger, it was impossible for it to be any of his DNA in there. But when it came to the hair in Ethan's hand and all the blood surrounding it, they didn't bother to do any additional work on that. That's Why wouldn't you push just as hard? Or for like the unknown DNA, like on several things, including the sheath, like why wouldn't you push further? And I mean, honestly, I don't know. Would Turvey know? Would Turvey know if that's not like what his position was? And he said himself that Ann Taylor made like sure that all of the experts and stuff were separate. Would he know? Like, because I just wonder, like, when it came to maybe Ann Taylor's alternate perpetrator stuff, maybe some of it was backed by DNA testing that maybe we don't know about. I don't know if he would know about that stuff. There's still like so much to this case that we don't have any clue about. And with the way that he said it, with the separation, I don't know. I just don't know if he would know. I wish we had some more answers. I'm sorry. I'm sorry. Good. Don't ever let her know that you even know about this case. Did you just figure that out? Oh my God. You've been here for so long and you just figured that out. That's horrible. Yeah. No shit. Like, I don't understand that. It's in his hand as he dies. You'd think that would be like the first thing besides the sheath that they would send off, right? That is so crazy. That is so crazy. Okay, so this is for Q13-1, the fingernail scrapings. Yeah. Statement of facts. I just want to see if it's anything different. Because we went through a lot of this stuff. In grand jury testimony, Jade Miller testified as to the results of testing done on item Q13.1, a swab of the left fingernail clippings for Madison Mogen. The data consisted of 3-person mixture. The statistic, the likelihood ratio, was calculated assuming that Madison Mogen was a contributor to her own fingernails. Miller testified that MM as followed. This DNA profile is at least 77,900,000 times more likely to be seen if it resulted from a mixture of DNA from Madison Mogen, Kaylee Goncalves, and an unrelated, randomly selected individual than if it resulted from DNA from Madison Mogen and 2 unrelated. See, this is always what pissed me off, is that they were making like nothing but guesses. I remember reading this before and saying the exact same thing. What do you mean that it could be Maddie Kaylee in one rando, or it could be Madison and 2 randos? You don't know. You don't know. They did that with the diluted DNA at the house too, in the common areas on the walls and stuff. Like, they gave a definitive for the main contributor of the DNA being Kaylee, but then they just said that the potential contributor to the secondary profile was Maddie. That's not a definitive answer. I've never liked that either. Yeah, right here. This is the exact same stuff we've read already. MM and KG and 1 unknown versus MM and 2 unrelated. Yeah, that made no sense how they couldn't be more specific. So what was it that was like? Okay, so here we have a report. Okay, do we have number 7? Let me go look. What am I looking for? Okay, the oh my God, Idaho State Police folder. Forensics. And then the lab reports. Okay, so see, this is another thing. There are a few, see, this is a 3rd folder that I already like kind of knew I needed to make. So over here in the drive, you see how I have 4383 and 4870 because there was the case number ending in 4870 when it came to like some of Jack Showalter stuff, Connor Chestnut stuff, a couple other things when it came to something that Jeffrey Talbot has his name on. Everything with 4870, as far as I can remember, is all Jeffrey Talbot. Everything with 4383 is all Blaker, which again, I always found really interesting considering that we were told from the beginning that Payne was supposed to be the lead, but his name really isn't on anything. It's mostly Blaker's name. Let me see if we have 7. Okay, we have, okay. Ooh, we got a new one. No, actually, hold on. Let me make sure. Let me make sure. Pretty sure this is redacted. It's going to take a minute to open. Okay, so, okay. Yep, this is the redacted one. So we've got a new one to add to the file. Okay, so this is page 5, I'm pretty sure. No, it doesn't go all the way to the end. It's only a few pages. Okay, so we have page 5 through page 7. And this is, actually, hold on. Let me see how do I have it labeled over here? It's just report 7 and then unredacted behind it. Okay. So 5 through 7. Report 7 unredacted. We do have new information tonight. Okay, let me add this to the Google Drive. My internet is acting so slow. Okay, there it goes. Oh, file unreadable. What do you mean, file unreadable? I think you're tripping. Let me try one more time. Yes, replace it. Okay, if the preview works, then it'll work. Okay. So I'm going to make a third folder for all of the ones that are very specifically cross-labeled, because we have a bunch that are for 4383. There's a very few of like amounts in 4870. See how like there's barely anything in 4870. So I'll separate those out. But now we have number 7 unredacted. So let's take a look at this, because we did not have this one. See, Directed Core number 1. Okay. So here is where we have the fingernail swabs. See if I can make this bigger for you guys. Okay. Okay. So they did a swab from the floor 2 bedroom and swab and debris from the F3 bedroom floor. See, I'm going to have to go back to the pictures to see what those were. Okay, so then we have the right fingernail clippings of Ethan in the left, and then the right and left of Xana, and then the right and left of both Madison and Kaylee, and then DNA extracts made from all of them. Okay. The DNA profile obtained from item 3 matches that obtained from the known reference sample of Xana. So item 3 from the second floor bedroom was Xana's. So I'll have to go back again in the photos and see what that was. And again, when I say photos, I feel like the best example of the photos with all of the numbering would be the files from 120, the ones that were really graphic. Those have all of the markers from what it seems. Okay, so this is where, what is this one? 6-1 is swab of right fingernail clippings of Ethan. It's a mixture. It says Xana Kernodle is a potential contributor to this DNA mixture. Yeah, see, in the other one, that's how in the redacted version, that's how we knew that Xana and Ethan, I believe they like both have each other's DNA like in their fingernails, right? Which is not abnormal. Not abnormal, and it that makes complete sense to me that that's the case. But now we have these other names. So let's see. Okay, so item 17 over here is a DNA extract of Jack Ducour right here. Then we have item 1, which is Showalter's DNA, and then Cole Barenberg's DNA is item number 2. These reports are in there. And then, honestly, why are we talking about item 1 right here? Three, 4, 5, 6, 7, 8, 9, 10. Why are we talking about item 1 right here? I mean, okay, they're excluded from being contributors. So Showalter, Barenberg, and then the Jose Cruz guy are completely excluded from the mixtures. .1 is what? Xana. And then Xana and Ethan. But see, again, it's always the word potential contributor to the minor component. It's never like a actual. But again, Ducour, Showalter, Barenberg, and Jose Cruz were excluded as contributors. Looks like Jack was too up here. Jack, Cole, Jose, all excluded from 10, which is the other side for Xana. Yeah, basically everybody's is like their own. Okay, so this is the 13.1 like full amounts when it comes to the mixture on. It's Maddie's left, right? Just want to make sure they actually labeled it. Yeah, swab for left fingernail clippings. Based on the likelihood ratio result of 0.399, it is inconclusive whether Jack Ducour is a potential contributor. Likelihood ratio 0.485, inconclusive for Cole Barenberg. 3.33, inconclusive for Ethan. 0.201, inconclusive for Xana. 0.0233, inconclusive for Bethany. And then Showalter, Jose Cruz, and Mortensen were excluded. And this is ISP's lab. So we know that the outside source, did we ever find out the name? I think we did. We did hear from them in the program that was used to do the exclusions when we got Kohberger's exclusion. I just can't remember what it was, but we did go over it. Whew. Okay, this coffee is really just not waking me up at all. And then 15.1 and 16.1 are Kaylee's. Yeah. No DNA was detected on swab number 4 when it came to the debris from the 3rd floor bedroom floor. Okay. Okay, so then we have report number 26. And there is stuff from, it looks like, the scene and also Kohberger's house. Yeah, his apartment. Okay, this is item number 108. I said something to you guys the other day that when you go to look at some of the information for 108, the oral swab taken of Kohberger after he got to Latah County, that one, when it was being sent over to the FBI, is the one that actually did have a chain of custody issue. And there was correspondence back and forth about the way that the locations needed to be corrected. So that was something that was noticeable when it came to the documents, but I can't find anything in way of the sheath itself going to ISP and there being a chain of custody issue the way that it's been described. Everything I'm seeing is a little different. Okay, so this goes all the way to 11. Let me get this one saved. It's another cross-reference one, so let me make sure 26. Yeah, 26 was one that we did not have. Okay, so 8 through 11. Report 26 under, oh, no, not that. Cancel. 8 through 11. I'm glad we got these because we definitely need to fill in these empty spots. Okay, let me make sure it's going to let me add it. As long as the preview opens, it should be fine. Okay. Oh, wait, cancel. Why would it be telling me that it's the same one? That's not true. It literally, it says unredacted behind that. Don't play with me. Oh, no, that's my bad. It's report 26, not 8. Okay. Let me try that one more time. Is it going to go in there now? Okay. Okay, so now the unredacted one is in there. Let's take a look at it, what it says. Okay, yeah, the DNA profile previously obtained from item 1.1, which is the knife sheath DNA, according to this, matches that obtained from the known reference sample of Bryan Kohberger. This DNA profile is at least 5.37 octillion times more likely to be seen if Bryan Kohberger is the source than if it was an unrelated individual randomly selected from the general population is the source. And then it says the DNA profile previously obtained from item 1.4, which is a portion of the knife sheath, indicates a mixture of DNA with a major profile. Assuming a two-person mixture, Kohberger is excluded as being a contributor to this DNA mixture. So that this was one of the other times where we saw that there was unknown DNA on the knife sheath and that Kohberger was excluded from being on 1.4. I can't remember what 1.4 was. But they ended up having 5 swabs altogether. The 5th one just wasn't, I don't think the 5th one even happened until December, I think. So then we have 6.1, which is stuff. Okay, so this is the fingernail clippings from the report number 7 that we just went over. They then took the oral swab from Kohberger and compared it against the 6.1, 9.1, 10.1, and 13.1 from all 4 of the victims. And it says that he is excluded from 6.1, from 9.1, and from 10.1. And then it says for 13.1 that it is inconclusive for whether Bryan Kohberger is potential. Now, this is the reason right here that the defense team went and had this section of it retested and was able to actually exclude him completely. See how they have all but one And I guess that if they would have just done the testing, I don't know why it ended up like that, with 3 of them being completely excluded and the other one being inconclusive when the other team went and tested it through to exclusion. So I don't know what happened there, but we do know from everything that went on in court that he was excluded from Maddie's clippings. So then we have item 23. And assuming a 2-person mixture, Kohberger, or actually it says Kohberger. That's crazy. Kohberger is excluded. No conclusions can be made regarding item number 30, but it has 3 individual DNA profiles. Item number 37 and 32, Kohberger is not the source. Yeah, see, I'm going to need to go grab the other reports. So what's number 13? Report number 13. Oh, we only have a redacted version of 13. Item number 30. Submitted swab of stain on bottom of handrail. No conclusions could be made, but there's 3 DNAs. Kohberger is not the source of the major male DNA profile from this item. Okay, so then we have, what was item 23 from number 13? I think it's bigger. Okay, swab above the stairwell was item number 23. Kohberger is excluded from that DNA. And then 37.1, 37.2 from report 13. Submitted swab from south entry hallway wall at blank apartment 1. Submitted swab from west kitchen wall at blank apartment 1. Is that, I can't remember if that's Decor or Showalter. Because I know that both addresses ended up with something. And I know that there was blood at Showalter's at like the hallway wall. Like the stuff in his bathroom, apparently the majority of it, if not all of it, I think, don't quote me on that, but the majority of it, like tested negative once they finally got in there. But I can't remember whose this is off the top of my head. I don't remember. I'm going to have to look and see. But we only have a redacted version of 13. As you guys can see here. So maybe one of these other files will have the redacted version. Okay, so then it says item number 40. Let's go back. Hopefully we'll get it soon. Okay, so then the stuff from the glove. The stuff from the glove. And Kohberger is not the source. No conclusions for 40.4, which is, I think, also part of the glove. Yeah. Swabs from inside the glove. Okay. So then, okay, so item 72, report 4. We do not have an unredacted version of report 4. We only have redacted. Okay, what item was it? Item 72. See item 14, report 4. Oh, that's just the reference card. Okay. Is item 14. So item 72 matches Kaylee, which is the submitted swab from the north wall of the stairwell. So this is like the common room report, I guess, really. Ethan Chapin, Xana, Jack, Bethany, Dylan, Showalter, Cole, Jose Cruz, Henry Clark. We're getting into some new names here. Kenneth Anderson, Donald McDonald, Mason Barstow, Jeremy Reagan, Koi Wynn, Derek Agbenya, Patrick Butner, Courage Alorbu, James Deskins, Connor Chestnut, and Kohberger are excluded. Item 73 is also Kaylee, with Maddie being the potential contributor. Again, that's part of the common area DNA. Again, Ethan, Xana, Jack, Bethany, Dylan, John, Cole, Jose, Henry, Kenneth, Donald, Mason, Jeremy, Coy, Derek, Patrick, Courage, James, Connor, and Bryan are excluded. 74, 75, and 78 are Xana, '74, second floor table. Okay, so this is the first one where it got screwed up. Submitted swab from second floor. '74, '75, '78. Submitted swab from second floor outside of bedroom. And they're saying that that was Xana's. Well, we know that this one was not Xana's. Then this one also says submitted swab of stain on floor near west bedroom. West bedroom was Dylan's if it's on the second floor. Yeah. So that, what is that? Did they swab the latent print? Because Xana's is east if it's the second. But they're not saying what floor 78 is. Hmm. '73 matches Kaylee. Yeah, we said that one. Okay, we said that one. And then 76 and 77 are Kaylee. 76 would be swab from the living room table. And see how they're like this is supposed to be the same table. Because remember, there was the mistake. So we've got blood on the side of the ping pong table, and then we have Kaylee's that we know is on the top of the ping pong table. But look how they're worded differently for the same thing. Second floor table and living room table. This should be the same wording to know that it's the same item. And why are they not literally one right after the other when it comes to the table? That's another reason why this was really confusing at first about like what table are they talking about? Because there's a little nightstandish type table right there next to the couch. And then there's the pong table. So I don't know why in the world they wouldn't word them the same. But it's really stupid, honestly. And then everything, all of the little blood samples from Kohberger's apartment match him. And then right here, item 108 was previously returned to the submitting agency. All remaining items have been returned to the main laboratory evidence vault for return to the submitting agency. Now, there's correspondence for item 108. I just need to see if we have it in these reports right here before I go and dig it out, because it was sent to me a while back. Okay, let me add this. Did I add this one already? I did. Okay. Okay, so, well, hopefully a bunch of these are like reports. That'd be awesome. Okay, so this is the original one about the 2014 cell phone. This is why I wanted to go in order by date, because there was a response first and we needed to look at this first, even though, again, like, it's nothing, but just to make sure that we're keeping stuff in order. And again, we know that they both agreed to that for some reason, which, I mean, it's great for the defense, but I just don't understand the state's stance there, unless they felt like they had to do him a bunch of favors because they knew they were full of shit. So this next one is a defense exhibit. Here's the okay, so this is for David Howell and Gary Shuttler. It looks like Howell was an Amazon Discovery. Yeah, Amazon Discovery opinion testimony will be based on his experience, education, and trainings as detailed in his resume for Amazon records. Now, I skimmed through this damn 31 pages, hoping that because it had something to do with Amazon, there would be a receipt. There wasn't. There's still not a receipt. But this is just basically his, I mean, this is why he's an expert person. I think we actually saw some of this stuff, because a lot of the stuff that they were going to be going off of is like just like browsing behavior. Plus, I also don't understand why they can't just let us have the damn receipt. Yeah, talking about the algorithm and how it does cross-platform tracking, AI, omni-channel shopping, Amazon advertising systems on click and purchase behavior, sponsored products, cart and wish list data, shared family accounts. Obtaining and reviewing Amazon data prior to March 2022 is critical to the ability to draw conclusions or put context into any purchasing. Now, at first, I didn't really quite understand like what this really mattered to, like, at all. But then we realized that there was a lot of stuff that was being purchased on this family account that sort of all congruently came together. Like, it all ended up coming together, like hiking stuff to be outside, stuff to be outdoors, different times, different purchases, different spans of time, but all very consistent to the behaviors, the hobbies, and the things that we know actually did happen and exist, regardless of what a lot of people want to pretend. I mean, pretty much his entire freaking phone is a bunch of selfies of him on hiking trails and stuff. Like, the dude was outside a lot. So when it comes to stuff for hiking and being outside and stuff, it's all very to theme. It's nothing unusual at all. Like, it's not like he bought a whole bunch of like unicorn and glitter and butterflies and then bam, knife sheath right in the middle of everything, and then went back to buying stuff that makes no sense. It's not like that whatsoever. It's all definitely stuff that works for somebody to have a hobby. And basically, without having all this other stuff and considering all the algorithmic recommendation tracking, the cross-device usage, all of the purchase history, browsing history, the way the family account works, blah, 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 then it's inherently incomplete. And honestly, I don't care about any of that. Like, I don't honestly care about any of this. Why can't they just produce the receipt? Why can't they just not produce the freaking order number and the receipt for the knife sheath? I don't understand what is so secretive about this damn receipt. I don't care about click history, search history. I don't care. Show us the receipt. It's so stupid. It is so dumb. I really don't understand the dumb shit, especially now. Like, look at this. We're almost a year, guys. At this point last year, we were still buzzing about the leak from Dateline. We are a month away from a year of the plea, guys. And they are still redacting Bethany and Dylan's names when it comes to stuff that we're having FOIA'd through in big old May 2026. And they still have not produced a single receipt from Amazon or the DoorDash photo, by the way. Oh, and you know what was interesting? I don't even know who it was. Honest on everything. I don't remember the person who I saw this from, but it was like a short on TikTok. And I guess we should have gone in and redone Molly's interview at some point, because in Molly's interview, Molly is asked by Payne if she received any communication from the person who ordered the DoorDash that night, and she says no. She says no, even though we know that the damn record shows that some sort of message got sent to her from the DoorDash account. I think it was an automated message. But she says no, and the record shows there was a message to get sent out. So kudos to who caught that, because I hadn't even thought to go back and listen to her. Why would you lie? Why would you lie? You're already admitting that you were slow. You already told us how horrible you are at doing this. Why not just be honest? Like, that's crazy. But here's all this guy's information. I'm not adding this to the file. And then we have Gary Shuttler, and he is someone regarding DNA testing and lab practices, analysis of DNA and DNA lab practices, and CODIS database expertise. Let's see what this says. I don't think we've seen this. I might need to add this to the file. Okay. So this is where we get into what he actually did here with this case. Materials received and basis of opinions formulated. There were 10 discovery submissions received in 2023 and 8 in 2024. These submissions included 95 folders, 31 subfolders, containing about 696 PDF files, not the bad kind, with over 15,000 of redacted and unredacted pages and over 13,000 photos, 375 JPEG files, 159 email files, and DNA data files. My opinions were formulated by examining these materials for information relevant to the forensic biology screening and DNA analysis work conducted in the investigation. These discovery materials included DNA analysis data, along with the lab reports, analyst notes, and worksheets from the ISP Forensic Lab. The ISPFS Biology DNA Casework Methods Rev 12, Biology DNA Quality Manual Rev 11, Evidence Procedures Manual Rev 2, and Quality Manual Rev 8 were also accessed. The above documents were reviewed as requested by counsel, and opinions were formulated. 1. I summarized and organized the results from the biology and DNA reports, reanalyzed the DNA run data, and reviewed analyst notes, worksheets, and reports for any significant shortcomings, mistakes, omissions, etc. No significant, impactful issues were observed in the protocols and procedures used. Now, remember when we were going through their argument for like lab protocol, and what we basically found out was that the Idaho lab created their own protocol that was not the same as like the nationally accepted or whatever, like protocol, but that it was a protocol that there was no problems with. So even though it wasn't the exact same kind of protocol that they should have been using, and it was again created for their own needs for the Idaho lab, everything was apparently acceptable. Like they molded and made it to whatever they needed for however they need to do things, and it was apparently completely fine. So keep that in mind because that happened. Okay, number 2. Overall, the ISPFS DNA analysis lab work, in my opinion, was done to a high standard. However, documentation in the case file was poor. Notes for evidence examination had minimal detail of how items were examined. This issue of concern was evident in the lack of detail documented about how the knife sheath was co-examined at the time of the biology and latent prints examination. This is true. The only description on the swabbing of the front strap was for the biology note stating used 1 swab to swab front strap. Item 1.1, V light gray transfer to swab consumptive. Now, remember, this is also, we have a freaking problem with the strap versus the snap, because they said snap for everything they possibly could in court and in some of the court documentation. But when it came to the actual forensic documents, it's never once said snap. And I've been trying to figure it out. Everyone's been trying to figure it out. They've never said snap in the forensic reports. That's another reason why when Turvey comes out and talks about the knife sheath DNA and he still says something about the snap, I mean, I don't really know what to think. So, oh, look right here, snap cap. Snap cap. Okay, let's see what this says, because that's been such a huge question. Both the latent print lab notes for Tina Walthall and the biology lab notes for Stephanie Wiltz did not have the detail of Riley Nowlin's December 12th through 13th, 2022 emails. Oh, this must be exactly what they were talking about. That's crazy. These are the ones that come out right after the book comes out. Okay. To Detective Talbot on how the knife sheath was examined and swabbed to preserve potential latent print evidence on the top of the snap cap. It required Ms. Nowlin to contact one of the forensic scientists to put all the detail together to respond to the inquiry from Detective Talbot on how that exhibit was processed. It certainly wasn't in either the latent print or biology notes from the discovery material examined. So that actually was the issue. He is describing the difference between the strap and the snap actually being a problem. No, the other word that he uses is a different word for sheath. He calls it a scabbard. That's the different word that you're thinking of. Yes, they were very specific, weren't they? Because it was, she said, like the inside of the button. See, now this is saying that it is a snap cap, which to me, if you're talking about the cap, then that's on the very top. But that's also why a lot of people were trying to figure out if it was the cap. They know that brass does a lot of degradation to DNA, to its actual like molecular structure. It completely breaks it down. But then we also know that they usually have some sort of like paint or something on top of the brass snap thingies. So when she was describing it as it being like on the inside, we were like, okay, well, I don't know if they actually paint the inside because it looks like it's metal. Usually it'll look like the shinier metal on the inside and then have like a shinier, more tan, like base shiny coat, sometimes even rubberized coat over the snap cap piece itself. So the whole time, us questioning that was actually the main issue, was the difference between Talbot saying that it was the snap cap and the fact that the 1.1 swab is literally labeled swab of front strap. That's why that we saw that. See, we were on point with what the problem was. Okay, so Detective Talbot put that information in these December emails. Okay. It certainly wasn't in either of the latent print or biology notes from the discovery material examined. Good documentation can prevent problems of this nature and help mitigate memory lapses. There were also at least 9 male DNA reference samples collected but not typed. They might have matched to unknown male B or D and provided pertinent information to help with the investigation. So that means that there's 9 male DNAs that were collected but never placed in to actually test. Nine male DNA reference samples also collected but not typed, and these could have been matches to the unknown male DNA. What the hell? But see, you know how much that tracks? What did Brett Payne tell us? That they were working on a suspect, that they were having these things tested, and then the FBI called and they literally shelved everything. He said they were looking at the lead suspect, got the call, they shelved the lead suspect, and then after the FBI call, they started getting information about there now being unknown male DNA in places, but because they already had the name of Kohberger from the feds, they just shelved all that too. So they had a lead before, they had the unknown male DNA after, and they didn't work any of it. Didn't work any of it. There are at least 9 male DNA reference samples collected that could have matched to unknown male B or D, or all the other freaking unknown male DNA. Holy shit. That's crying. Okay. There are limitations of what information the forensic biology and DNA evidence analysis results can provide. To understand the DNA evidence in this homicide case investigation, it is helpful to consider the following questions. In particular, for the only DNA profiles reported that were recovered from inside crime scene evidence that were not consistent with any of the victims, it is not unreasonable to expect that the perpetrators of such a violent crime would have left traces of DNA and possibly blood. So this is an exhibit for the defense that was filed to the court on March 3rd, 2025. So I'm going to assume that since Turvey knows exactly about the Talbot situation with this, it seems, then I guess he would know if in 3 months there was literally no testing done, even though it looks like Anne was very well aware that there was at least 9 males that were swabbed at some point and then never even bothered to have placed in. That's crazy as hell. That's crazy. Okay. Whose unknown DNA was recovered from the DNA evidence? There were only 2 unknown male DNA profiles reported that were recovered from the inside crime scene evidence that were not consistent with the victim, Ethan Chapin. One was called unknown male A from item 1.1, swab of the front strap of the K-bar knife sheath found close to a victim's body. That's the one they're telling us is supposed to be Kohberger's profile, of which only the defendant cannot be excluded as the contributor. The other was called unknown male B from item 30, a swab of a small red stain on the underside of the stair handrail north wall between the first and second floors. And then that is ISP marker identifier B. That it's excluded all 18 males who had their reference samples collected and tested. This presumed bloodstains location was near presumed bloodstain item 31.1, which is identifier D, which is the non-diluted, meaning full strength, of Ethan's blood. And presumed bloodstains item 72 on the north wall of stairwell and 73 on the half wall. This would be number 23 and 26 that were reported to be consistent with victims Kaylee and Maddie. And then, of course, we do have those photos. What body fluid / cell material did the DNA come from? No body fluid testing of the item 1.1 swab of the K-bar knife sheath front strap was reported. A positive presumptive test for blood was reported from the item 30, a swab of a small red stain underside of the stair handrail, north wall between the first and second floors. What I'll end up doing is going in and clipping out these documents separately. And when I do this one specifically, I'll make sure that I add in photos from the drop that match these item numbers so that we can have all of the visuals in the review. When did the male DNA get deposited? There are no reliable, widely adopted tests to determine when DNA from biological material was deposited. In this case, neither of the item 1.1 swab of the K-bar knife sheath front strap male DNA profile or the item 30, a swab of a small red stain underside of the stair handrail male DNA profile exhibited severe degradation, often associated with old deposits of biological material. Neither of them did that. Okay, so neither of them exhibited severe degradation associated with old deposits. So he's even saying that 1.1 that was supposed to be Kohberger's is also not showing degradation. Okay, that's interesting. Okay. Now we have D. How did the male DNA get deposited? The DNA recovered from item 1.1, swab of the K-bar knife sheath front strap, could have come from direct contact if from skin cells and or by deposits of body fluids with DNA content such as saliva or sweat. There is no confirmatory test or standardized set of factors to support that a specific sample was deposited by direct means versus indirect means, which is like the Walmart cereal aisle that we talk about. A probabilistic mathematical approach would be required to evaluate one activity as opposed to the other. The DNA recovered from the presumed blood stain on underside of the stair handrail north wall between the first and second floors, item 30, must have been deposited after some minor injury by direct contact or indirect contact, secondary transfer, but it cannot be determined if the DNA recovered was deposited passively before the crime or actively, meaning during the crime. Number 4, there were missed opportunities with the CODIS system. The number of perpetrators involved in committing this complex crime is unknown. It would have been prudent to have considered that more than one of the unknown male profiles might be involved and use CODIS to help answer that question as a case approach strategy by the lead law enforcement agency instead of assuming only one possible perpetrator. So that means that those 9 male profiles never got pushed through CODIS either? Wow, okay. Only unknown male A was searched and uploaded to the National DNA Index System, NDIS database. Furthermore, not all forensic unknown DNA profiles are eligible for the NDIS upload and would only be in the state DNA index system. Manual or one-time keyboard searches can be done with forensic unknown DNA profiles that have a minimum of at least 6 original CODIS car loci and a moderate match estimate MME of at least 60,000 as calculated by the CODIS software. Laboratory to laboratory one-time search requests can be done between NDIS participating laboratories to search SDIS databases from neighboring states. No manual search requests appear to have been made for any of the unknown male profiles A, B, or D. So they didn't even bother. They legit did not even bother. Okay, so does he have these on here? No. So he I guess references the photos right here, but he doesn't have them actually attached to the file. And then this is like his history and everything that he's done. Yeah. Okay, well, I'm going to take this out separately. So this would be, that's the only piece with any information, right? No, I guess the whole thing. So Howes is 1 through 5. Interesting. So we have defense expert David Howell, Amazon. That's crazy. Lots of information in this one. 6 through, I don't want all this stuff right here. I guess I can do this much right here. 6 through 12. Defense expert, Shuttler, DNA. Unbelievable. 9. 9 unknown male DNA. That never got ran through and tested or anything. That's crazy. That's actually crazy. I mean, honestly, it's a lower number than I thought it would be. It's a lower number than I thought it would be. That means that all of the names that we read, there's 9 more names that we don't know, I guess. Because they haven't been placed in the system. Okay, so then we have this defendant's notice of filing signed, notarized affidavit. Okay. Notice of filing signed and notarized affidavit to the defendant's motion to strike death penalty regarding autism spectrum disorder under seal. Okay, so yeah, this Dr. Cecile Reynolds, I remember we read something from her. Is this it, or is this a new thing? Oh, she's in Texas. Well, we're going to read it anyway because it's only like 1 page. So this says, I have been retained as a consultant in issues of mental health and neuroscience by the defense in Mr. Kohberger's case. One of my key roles in this case is to assist the defense team in locating and securing the work of the most appropriate and properly qualified experts in the fields of psychology, neuropsychology, and forensic psychiatry. Can y'all see this? Okay. During my work with the defense team, on my recommendation and after extensive vetting, they selected and hired Dr. Joette James, neuropsychologist. She performed many hours of work, including testing Mr. Kohberger and conducting collateral interviews. Over the course of many months, she collected data and prepared to write a report. She had 1 additional round of tests planned to clarify diagnostic issues present with Mr. Kohberger prior to writing her report. Shortly before that trip, Dr. James unexpectedly passed away. Oh, yeah. I did remember there was an expert that died. I do remember that. But we never had the name until now. Wait a minute. Hold on a second. I thought it was a state expert that died. Because the state asked for a continuance for something because somebody passed away, did they not? Or was it because somebody quit? Or somebody quit. Okay. The state asked for a continuance at one time because one of their experts literally walked the frick away and quit. And I do remember them saying that something had happened to one of the defense ones. I don't know what she died of. Dr. Joette James, neuropsychologist. Let's do a little Googling. Well, let's do a little Googling actually on Google. My shit is running so slow. Oh my God, come on. I'm going to have to redo this router when I get out of here. Let's see. She was the board president of Hamiltonian Artists.org. Let's see what else. Yeah, obituary. December 2024. But then this goes back to October of 2024. Ivy Mountain community is both celebrating the life and mourning the passing of Dr. Joette James, a clinical neuropsychologist. She was on this board too at the Ivy Mountain Center. Okay, so you type in Joette James, neuropsychologist, cause of death, and it says, let me make this bigger. The exact cause of death for renowned clinical neuropsychologist Dr. Joette James has not been publicly disclosed. She passed away suddenly in the summer of 2024 at the age of 51. Well known for her forensic evaluations supporting capital punishment defense. And she was working on a capital case on the defense team. I don't know. I'm going to have to dig a little further and see what I can find. But that's interesting that it's not just, somewhere out there, especially in an article or something. That's interesting. That's interesting. I'm definitely going to look and see what I can find. Okay. Did we look at that whole document? No, we didn't. Let's finish reading the document. There was, okay, one of them mentioned a rapid illness. Okay, I couldn't find it. I'm going to keep looking. I'm going to keep looking so I can see. Okay, let's see. Well, see, okay, well, you're saying they said something about, a rapid illness. Okay, well, rapid illness would work for the unexpected portion of this statement. I don't know. Okay, anyway. Shortly before that trip, Dr. James unexpectedly passed away. I was able to interview her regarding her incomplete impressions and, again, incomplete testing data, and developed an understanding of the additional work required, which included the addition of a forensic psychiatrist to the team. She was unable at that time to forward her records, testing, and notes due to me due to the severity of her illness and its unexpected and rapid onset. Oh, it says it right here. Okay. So, well, that at least tells us it's a medical thing. Severity of her illness and its unexpected and rapid onset. Oh, well, that's a little sketchy. Unexpected and rapid. You hear that a lot with poison cases. Okay. After her death, I assisted the team in interviewing and selecting an expert to assess Mr. Kohberger. It was necessary to review and vet multiple experts to ensure the proper expert would be retained. The team subsequently selected Dr. Rachel Orr, that's the name that we heard before, as a replacement for Dr. James, and added Dr. Eileen Ryan, we heard that one before, forensic psychiatrist whose expertise was then also required. I made several attempts to obtain the raw data from testing performed by Dr. James. I was not successful. As a result, the neuropsychologist hired by the team had to conduct testing and interviews as if none had been done previously. So they had to go through the entire process all over again. I don't understand how there wouldn't have been somebody over at Dr. James's office that would be able to send over all of the information. Yeah, that's my question. So they never got the records? I don't understand that. There's no way that Dr. James, with as renowned as she was, with as many boards as she was on, with as many people that we have articles writing about her and the impact she had on all these different organizations, that she doesn't have an office full of people that knew the files that she was working on that would have sent the stuff where it's supposed to go. No, Sue, she didn't quit. She died. Yeah, like, where's the staff? That's definitely item number 6 that's got my attention tonight that we need to look a little bit further into. I don't understand this. Everything she was working on should have been transferable, especially since there was contracts with her to do the work. So it's not like she had it and wasn't supposed to, and then that's the issue. Like, all of it was, wow, okay. That's something we're going to have to look at. This substantially delayed the development of a full understanding of his neuropsychological status and the determination of an evidence-based defensible diagnosis of his multiple mental conditions. Dr. Orr and Dr. Ryan have worked diligently to learn about Mr. Kohberger, review materials related to the case, conduct interviewing and testing, analyze the data, and write an expert report. And the defense team has made every effort to assist them in completing their work in the most timely fashion possible without compromising the integrity of their work. Neither Dr. Ryan nor Dr. Orr were able to present their findings to the team and develop initial reports until mid to late January of 2025. Given the amount of work that had to be done, including in-person exams, reviews of extensive records, conducting many needed collateral reviews, and the like, I was frankly surprised either expert was able to respond as quickly as they did. The delay in diagnosis did not occur due to lack of diligence, is owing to the untimely and exceedingly unfortunate death of Dr. James. I don't understand how her files were not transferred over. This is an interesting ass document. Interesting. But it shouldn't be, because it was work product and it was for that case. Everything that she was doing should have been sent over to the team, to the new person that was taking over the role. It being psych records doesn't have anything to do with anything. This was what the job was. That makes no sense. That makes no sense. Okay. So then here is Exhibit A to defendant's 7th motion to compel I do remember seeing something like this, but it's actually up here. You guys are probably going to recognize it. Y'all remember looking at like this one before? Like all the different back and forths and stuff like this. The majority of all of this is stuff that we've already gone over. I don't know if they've added anything else. I don't exactly remember what it was that they had redacted. Let's take a look real quick, because then they do have the response. So this is the 7th motion to compel, Exhibit A. And we got Detective Gilbertson's curriculum vitae in the records that came out for March of 2025, those same ones that I said were taken back, but we got those exact same ones again today, that they finally put them back. That right here for Gilbertson is in there, so we've got it twice. Defendant's 22nd supplemental request filed on 1/28/25 for all Othram lab protocol policy and procedures and validation studies in place in December of 2022, as testified about by Matthew Gamet in that closed session in January of 2025. There's a lot of information that came out of that one. The state objects to this request as untimely and improper. Matthew Gamet testified about Othram's protocols and procedures in the context of the bidding process. The documents related to the bidding were included in or referenced in the materials provided to the court to review in camera. The court required the state to discover only the MOU from the bidding documents. The court did not require the state to produce any of the other bidding documentation, including Othram's bid submission that discussed Othram's accreditation status, which was an issue at the time, other customers, past cases, the name and qualifications of the primary genealogist, the name and qualifications of the chief scientist, and the SOPs or analytical methods that were to be used. Though the SOPs were inadvertently excluded from the materials reviewed in camera, the bidding document referencing the SOPs were included, and the court did not require disclosure of that document or the SOPs. If the defense thought it should have access to any of the protected materials, the proper procedure would have been to move the court to reconsider its decision on the protective order, and the proper time would have been prior to the defense's deadline for discovery motions. It would have never budged. They would have never removed the protective order. What an ignorant statement. What an ignorant statement. Come on now. Now, we also know that Othram failed. When they did their little interview, they said that they promised them a 72-hour turnaround time, and 18 days later, all they had were some distant cousins that didn't want shit to do with anything, according to them. That's why they had to send everything back, because they didn't do their job when they said they were going to do their job. That's why it's better for that kind of stuff to be used for cold cases, because sometimes it's just not that fast. And whenever they're trying to keep a case going, hot, I guess, because that's the opposite of cold, you shouldn't be using one that has to do the things that cold case DNA does. That's not going to work. And I don't know why in the world he made himself sound like they could do that in 3 days. I don't know why he did that. All Othram lab materials created, collected, or held pursuant to the policy and protocol in place, as testified to by Matthew Gamet on 1/23/25. All bench notes, original electronic data files, photographs, quality records, including positive and negative controls, and degradation, contamination documents, bioinformatic methods, and documents related to case file 22112201. Untimely, improper. All documents and records produced to the FBI, including but not limited to documents and records from Othram, Moscow Police Department, Idaho State Police, Latah County Prosecutor's Office. And again, they're trying to say it's untimely and improper. The FBI's letter dated November 28, 2023, which the state produced to the defense on 1/29/24, explains that the FBI provided all the materials in its possession related to the utilization of IgG in this case to the court for in-camera review. The state disclosed to the defense everything ordered to be disclosed by the court after its in-camera review. Yeah, that's the stuff from back with Latah County. The requested materials either do not exist or were protected by the court's decision not to require the state to disclose them. Everything should have to be disclosed. F all that. All written notes, records, emails, research, or documentation of any kind by Matthew Gamet regarding his efforts to research and obtain voluntary DNA to assist Othram's work to identify the contributor to the DNA on the sheath. What does that mean? Matthew Gamet regarding his efforts to research and obtain voluntary DNA to assist Othram's work. What does this mean? What does that mean? That Matthew Gamet, because he's like the lead, the director of the lab. Does that mean that he was like going around trying to get people to give samples? Matthew Gamet regarding his efforts to research and obtain voluntary DNA to assist Othram's work to identify the contributor of the DNA on the sheath. The state received the above requested information from ISP legal counsel. This information will be forthcoming in discovery. I think we need that. I think we need all of that. Thank you for the $1.99 Inktfinity. I appreciate that. Thank you. Thank you, thank you, thank you. I was able to look up the doctor passed away from cancer. Okay, so it just must have like showed up and went crazy. And thank you for being a member. I appreciate that. Yeah, I mean, my sister's friend's mom got cancer, and she went from not having any symptoms to passed away in just a matter of months, and there was nothing anybody can do about it. And it was sort of the same when my mom's husband got cancer. He was sort of fine, and then he wasn't, and then like it didn't take long. So it does happen. It can like show up sort of like out of nowhere and just take off, and there's not a lot you can do. That is very true. So hopefully we can get this information, because I want to know what the hell Matthew Gamet was up to. That's interesting. To assist Othram's work. Obtain voluntary DNA to assist in Othram's work. But they didn't actually do anything. That's an odd-ass freaking statement. This has got my attention. On February 11th, 2025, the state received the above requested information. So that means that I could ask this question. Like, can I take this section right here and copy and paste it into a FOIA to ISP? I bet you I can. Matthew Gamet's always the one that ends up replying. So that'll be interesting. It was really interesting when I asked him for his notes from whenever him and Laker went to Othram. All written notes, reports, recordings, or emails related to Vicky Gooch's investigation, interviews, and any efforts made to obtain voluntary DNA to assist. I don't like it. Like Vicky Gooch, I can understand because she was an officer who went around and did interviews, obviously, right? Because it says investigation, interviews, and efforts made to obtain voluntary DNA. Like I can get her going around and doing interviews and taking swabs, but Matthew Gamet being boots on the ground, going around and getting swabs of people. He never left the lab besides going to Houston and then to Utah before he got back to Idaho, you know? But when it comes to interviews and stuff, there's no reports of him doing any stuff like that. Literally at all. So that for Matthew Gamet is crazy to me. Okay. So for this one, it says they've inquired as of March 6, 2025, the state has inquired legal counsel for ISP about this information from Gooch, and I don't know if they've got it or not, but I guess we'll see in the next document. A copy of all records the FBI received from Othram, including but not limited to all records, bioinformatic methods, and documents related to this case file. So does this mean then that Othram sent stuff directly to the feds and like ISP didn't play the middleman then? And this is just the same response about the November 2023 letter. All records related to entry in databases GEDmatch, GEDmatch Pro, Family Tree DNA, MyHeritage, and Ancestry.com. Defense already tried requesting the same and similar information. Parties litigated the issue, and the court ruled that the state did not have to disclose this information. Yeah, they protected all the damn lies. Copy of GED.com file that is part of the Ancestry Tree building, as testified to by Dr. Leah Larkin. The reference to Dr. Leah Larkin's testimony on 123.25, as if that is when the defense first learned of a GED.com file, is at best misleading. The state sought a protective order for the IGG information in this case. The district court ordered in-camera review of the IGG. Yeah, that's the same thing that we talked about earlier. A digital version of the family tree exists in the form of a GEDCOM file and is available for in-camera review by the court upon request. I wonder, since everything is open now, sort of, if I could FOIA the family tree information the way that they have it. Like, I wonder if they could give it to me with like the names redacted, just to see the way the tree is actually put together, but like with redactions. I wonder if they could do that. Viewing the digital file requires downloading proprietary software. Examples of websites offering such software include Ancestry.com, Genopro.com, FamilyEcho.com. The additional data associated with the individuals as described above are not available via the GEDCOM file unless accessed via Ancestry.com. The defense's attempt to obtain an already protected file by sending the state a new request is improper, because they already tried it, we're told now. So, okay, whatever. Identity of FBI analyst creating the SNP or SNP utilized by the FBI in its genetic genealogy investigation. The request is also factually inaccurate in that no FBI analyst creating a S&P profile in this case, as the state explained to the defense in a letter dated October 11, 2023, when it disclosed the two versions of the S&P profile. For context, on November 22, 2022, a portion of the DNA extract was personally delivered to Othram Laboratories, a private lab, from ISPFS on 11/22/22, so crazy. Using a portion of the DNA extract, Othram performed a DNA test called forensic grade genome sequencing. This created a SNP profile. This SNP profile was uploaded by Othram to begin genealogy research. On December 10th, 2022, Othram was instructed to cease all work on the case. Again, because they promised a 72-hour turnaround, and 18 days later, they didn't have anything. Per instructions, Othram transferred all genetic genealogy database credentials to the FBI. Emailed login instructions and password. So yeah, so they did not use ISP as a middleman. Othram sent everything they had directly to the feds by giving them login instructions and the passwords for the databases that Othram was working on. Interesting. Okay, that's more specific detail. After this transfer, Othram no longer had access to the genetic genealogy database results. As a result, we are sending you two SNP profiles, one developed by Othram and the one from the database transferred to the FBI. And remember, Leah Larkin said that the Othram profile that got sent over to the FBI, once it got to the FBI, it was like more than double in size. And she doesn't understand how that happened, because that's not normal. We probably should go back over some of those expert reports. Not reports, but like the expert testimony. I know I've mentioned that before, but I will eventually go back over some of it. Process used by the FBI analyst creating the SNP profile utilized by the FBI in its genetic genealogy investigation, including the type of bioinformatic programs used in any and all quality assurance control manuals, quality control manuals, or protocols, as well as validation studies of this method. See response to request 432. So the one up here, the exact same thing. Okay. Identity of FBI IGG FIG analyst performing the genetic genealogy investigation. FBI explained to the court in its letter dated November 28, 2023, personally identifiable information pertaining to the identities of those sending receiving correspondence have been redacted from any items. See, I don't understand. How come when it came to certain things, like the car, like the cell phone stuff, they let us know, like, the agents' names? Like, we know several of them. We have S.A. Douglas, we have Heal or Heil, however you say it, Hill, maybe Hille. What's the cell phone guy that also did the other case with Lori Vallow? What's his name? I can't remember his name. You guys know who I'm talking about. He was on there. There's like several of them that we've already been told their names. The stuff's in the documentation. So I just don't understand why for some of it it's like so secretive, and for some of it they don't care if we know who it is. It's kind of stupid. I don't really quite get why nothing matches here. Results for the IGG, FIG research in each of the following databases. Defense already tried requesting the results. The parties litigated the issue and said that the state did not have to disclose it. I wonder if they got all this afterwards. Did they get all this stuff afterwards? Balance. That guy. Yeah, Balance or whatever it is. Yeah, that guy. Like, how come we know like 3 or 4, maybe 5 names of these federal agents that were working it? But like for some of them, they're like, nope, you're not allowed to know. That's wild to me. I don't understand that. I feel like that's pretty stupid. But yeah, I wonder if now that this is all done and over with, if all these things that the court ruled the state did not have to disclose when it came to the IGG, I wonder if it's now been disclosed. Because the rules kind of change a little bit now, right? I'd like to know. The defense's attempt to obtain information the court already ruled that the state does not have to provide by sending the state a new request is improper. Oh, boo-hoo. All work done by any FBI analyst, investigator, officer, or IGG FIG persons working on behalf of the FBI in researching, interviewing, and testing any collateral contact for genetic testing. And then this just says the same thing about the FBI letter from November 2023. Any and all communications between Moscow PD, Latell County prosecutors, Idaho State Attorney General, or FBI with Othram Labs regarding the SNP testing and genetic genealogy research conducted by Othram after 12/10/22. All non-attorney work product emails regarding all of this stuff were ordered to be disclosed after the court's in-camera review and have been previously provided. Okay, so then when it comes to there being more of a response to this stuff, is it all the same? No, there's more. Defendant's 22nd supplemental request filed 1/28/2025. Let's see. The state notes for IGG related materials. The defendant filed a motion in limine, exclude IGG evidence on February 24th, 2025. Asking this court exclude IGG evidence, the state filed its response stating, as the state has explained as far back as the beginning of the litigation over the IGG, and as recently as its competing motion in limine filed contemporaneously with the defense's motion, the state does not intend to introduce the IGG information at trial other than to help the jury understand how the investigation progressed. The state can do so by referring to the IGG information. Yeah, this was where the lie got started. As a generic tip without revealing the source or the substance of the tip. An investigator can simply testify that law enforcement received a tip and that based on the information received, law enforcement took the next step in the investigation. Yeah, this is where the lie for Payne coming in and downplaying the entire thing. This is where it started, right here. Then we have, that's all the same. I think the red stuff is like the only new thing here. Okay, so for all written notes when it comes to Matthew Gamet regarding his efforts to research and obtain voluntary DNA to assist Othram, the state amends its response as follows. The state has determined that Matthew Gamet's email regarding Othram were already provided. Oh my God, so there were emails. He lied to me. Bruh, I know you guys remember that I very specifically asked for email correspondence, and he told me there was none. He only sent me receipts. Because remember, my whole thing was, well, then how did y'all even plan it? Like, was it only on the phone with phone calls? Like, there has to be some sort of email trail from MPD to ISP and planning that, like, who chose that Blaker got to be the person to go with Gamut? Who decided that it was Gamut? Like, I asked very specifically about anything regarding Othram in his freaking emails, and he straight up told me none. He straight up told me there was none. Oh, Matthew, you're getting a phone call Monday. Unbelievable. You liar. You liar, liar, pants on fire. How dare you? I have the emails too. I specifically asked, how did y'all plan it without emails? Like, how did y'all have a conversation? Like, where's the conversation that planned all of this? So tired of it. Oh my God. Thank you for the 5 gifted memberships, Wisteria. I appreciate that. Thank you. Congratulations to those who get those. I cannot believe he lied to me. Oh, I'm recording it. I'm calling him on Monday. I don't give a damn. This is dumb. Unbelievable. Page 3 of which one is this? So mad. Discovered on January 29th, 2024, and discovered again on May 17th, 2024. So it's in there double, and he still lied to me. Typical man. Freaking liar. Oh my God. Okay. So let's go to Vicky Gooch's. For her interviews, investigational interviews, or any efforts made to obtain voluntary DNA to assist Othram's work, it shows that there is no information. Detective Vicky Gooch has indicated she was directed to make a phone call to an individual, but she does not remember the person's name. That phone call was not productive, and she did not take any notes. She did not make any further efforts to obtain voluntary DNA. Oh, is this them trying to go in and get the cousins? Is this them trying to get the cousins? Maybe Matthew Gamut called and, like, they wouldn't deal with it, so they sent a chicken to call and they still wouldn't deal with it. That's crazy, and she doesn't remember who it was? Oh my God. I wish the cousin that was contacted would come forward. Just tell us who you are, bro. Like, you're so far related. Like, it's just a story. You know, you're going to tell your grandkids on the front porch one day in your rocking chair. Just go ahead and tell us. Let's hear it. I want to know what they said to you. Oh my God. Okay, let's see. Any more red stuff on this thing? Nope, that's it. Well, I'm glad to know that we found out that Gamut's a freaking liar, liar, pants on fire. How freaking sad. Sad. Okay. So then we have the state's response to defendant's motion in limine regarding inconclusive data, which is the response to the document that we looked at earlier about the fingernail clippings on Maddie's left hand. I mean, we've honestly already read this document. We know that the DNA is not Kohberger's. Let's see. Yeah, this is okay. Value less than 0.01, that supports exclusion. So exclusion of someone being a contributor of a mixture. And then it says these ranges are consistent with the Idaho State Police Lab's analytical methods. Applying those ranges to her likelihood ratio results. And see, that was also the issue with why the policy for the lab was important, because their likelihood ratios, like, they were their own standards. It wasn't the national standard when it came to DNA likelihood ratio. It was their own standard that was created. And that caused issues with the way that their wording came across, for the way that their results were done with their own protocol set in place. Again, of course, the most ridiculous stuff literally ever. But this is where, following the lab standards, that potential contributors could have been, no, it makes it inconclusive whether the following persons are potential contributors, and that would be Jack, Cole, Ethan, Xana, and Bethany. She also determined it is inconclusive whether Bryan Kohberger is a potential contributor to 13.1. The defense has disclosed Jennifer Bracamontes, a casework manager at Cybergenetics, as an expert witness in this case. Ms. Bracamontes utilized a different program than ISP to analyze the DNA profile obtained from item 13.1. She determined that Bryan Kohberger could be excluded from the DNA profile obtained from Q13.1. And it says this court should deny defendant's attempt to exclude Ms. Miller's inconclusive result as the defendant. No, they shouldn't. It should go away, because we know that it's not true. Inconclusive means there's still a possibility, and it was tested all the way through, and it should have been removed. That was always the right answer. Always the right answer. But this, again, it's like stuff that we already know all the answers in the way that everything concluded. This is just them finally releasing some additional information. So this is state's response to defendant's motion in limine number 14 regarding statistical analysis. Let's see what's all on this one. Oh, this is for grand jury stuff. Okay, defendant asked this court to exclude a specific question asked in the grand jury and other questions in testimony, such as that question. The state will not ask the same question asked in the grand jury because, as the witness explained in response to the question, it is not a helpful way to discuss the likelihood ratio. Okay. However, the state objects to defendant's request for an order vaguely excluding questions and testimony such as that. Talking about likelihood ratios. The state plans on eliciting testimony consistent with this explanation and the relevant lab reports. When it comes to a likelihood ratio, is basically, it's a statistic that compares the probability of the evidence. And when I say of the evidence, I mean of the DNA profile we obtained from the evidence. It's the probability of that evidence under two different hypotheses. And one, in this case, when we're comparing Bryan Kohberger's reference sample, is the hypothesis that he is the contributor or the source of the DNA, versus the hypothesis that it came from an unknown, unrelated, randomly selected individual. And when we compute that statistic, we, of course, in this case, got that number 5.37 octillion times more likely, which I also just described being on a range of scale of the numbers that you can see for statistics. It's a very high number. So it's extremely strong support that shows inclusion of his DNA in that sample. So you'd be that many times more likely to see that DNA profile if he was the source of the DNA. That's the explanation that they plan on, I guess, giving out, or were planning on giving out to the courtroom to explain likelihood ratios when it came to all that stuff being talked about in front of the jury. That was the plan, I guess. Okay, so then we have exhibits 1, 2, and 3 to defendant's objection to state's motion in limine regarding the admissibility of the demonstrative evidence, which is that damn dollhouse. Why do we need 26 pages for the dollhouse? Please explain. Let's see. Oh, it's more than that. Okay. Okay, so exhibit 1, defendant's 11th supplemental request for discovery. Exhibit 1A is the state's supplemental response to the defendant's 11th supplemental request for discovery. Exhibit 2 is an email chain between Ashley Jennings, Bill Thompson, and Ann Taylor. And then exhibit 3 is an email chain between Bill Thompson and Ann Taylor regarding new discovery disclosure. Oh my God. But are we going to get to see them? This is about, okay. Oh my God. Okay, yes. Item number 11 was 1122. I mean, the 1112. Oh my God. Okay. 11 supplemental request for discovery, Exhibit J. Oh, hold on. My face is in the way. Let me over here for a second. Okay. Okay. All audio to all video available from 1112 King, including from 11:13:22 at 55 a.m., which is 12:55 a.m., through 11:17:22. Audio has only been provided. Audio has only been provided. Oh my God, this is the same problem we have. Audio has only been provided from 11:13:22 at 2:25 to 12:05. Okay, so when we first got the 11:12 footage, it started at 2:25 in the morning and it ended at 12:05 p.m., 5 minutes after the cops and everybody started showing up. So 12:55 to 2:25, when we finally got that file, there was no sound, okay? We are seeking all audio and video that exist from this camera. We are missing sound on 11:13:22, 55 to 2:25. Now remember, there was a hearing in 2024 where she stated that this was no longer a situation. Pretty sure it was 2024. I'm gonna have to go back and check what the hearing on Lucy's post. But I've shown it to you guys already. We talked about this, where she said this was no longer a problem. But she was missing the exact same shit right here. We are missing sound on 11:13:22 from 12:55 to 2:25. And then from 2:05 p.m. through 11:17:2022 to 17:22 p.m. is silent as well. So there's only sound from 2:25 in the morning to 12:05 p.m. So we did have the original problem that Ann Taylor is claiming that she had with the footage. That's what I was trying to explain when we were trying to figure out why the timeline is saying that they heard sound here. Because we were not told that it was redacted. We were told it was completely just not there. Based upon information we have reviewed in discovery, we believe there is video footage prior. Oh, so they're not just saying, oh. So if this was no longer an issue because she said she got what she was asking for with number 11, does that mean that she actually got footage from before 12:55 a.m.? We are requesting all footage, audio, and video that exists from the King Road camera prior to 12:55 hours. I wonder if that means there's actually more footage. Complete copy of SD card from 1112 King. But the SD card, there was like an issue and he couldn't get anything off of it, and then it was given back to the owner. The SD card itself. I'm going to have to go back into the documents and see if it was ever like gotten back to try to look at it. But we know that from the 13th through the 19th, he was failing at everything that he was trying. Mallory was. It wasn't until the 19th that he logged in on his work phone through the same app that all these other people were using to log in and look at the footage. And that's how he was able to get it. Surveillance camera footage from Latell County courtroom from the 10/26 hearing. Follow up on investigation related to Shannon Gray media sources. Identity of all certified CastViz users within the Moscow Police Department and certifications. CastViz logs showing the date and time when Officer Mallory examined the records as he documents in his 5/3/23 supplemental report. See, it was May of 2023 that she had the hearing where Mallory was on the stand and said that he had just gotten her a bunch of stuff like that morning. And that's where she says that there's issues with 1112. But it was in 2024 where she said that there was already like stuff was handled already. So, okay. Any exhibits created by Mallory while using the CastViz program during this examination with dates and times they were created. All information, documents, and data related to the AT&T Hemisphere program, also known as Data Analytical Services, or DAS, in the investigation of the homicides at 1122 King Road in Moscow, Idaho, and the investigation of Bryan Kohberger and or his prosecution. This request includes, but is not limited to, the identity of any and all law enforcement, including the FBI cast members or other officials who participated in the investigation relating to this program, the date and time of the query or records request, or any other access to AT&T or through AT&T programs, digital copies of all data provided as a result of the request, AT&T specific records of all inquiries made by any person, entity, governmental agencies, or internal software program pertaining to the AT&T phone number, which we know is his, date of the request, law enforcement official making the request, a complete copy of all data as a result of the request. Okay. Complete copy of all materials relied upon by Corporal Payne in his affidavit for the search warrant to AT&T, the second warrant, issued on 12/23/22 at 16:53 hours by Judge Megan Marshall. This requests include, but are not limited to, okay, so all the notes, reports, FBI special agent information, okay. All information, documents, and data related to mobile advertiser identification number, MAID, inquiries related to the investigation of the homicides at 1122 King, or the whole thing. This includes, but is not limited to, disclosure of any research or inquiry that was done utilizing a database to determine location information or any format of any mobile device. This request includes specifically reverse geofit searches of MAID data, direct location search related to MAID data, any search to discover mobile device MAC identifiers, MAC identifiers, any search that would produce any location data of any mobile device done outside of a previously disclosed search warrant. Number 230, complete corrective actions log as indicated by Riley Nowlin email that would be available electronically. Number 231, yearly audit reports for ISP Forensic Laboratory for 2023, 22, and 21. Idaho State Police Forensic Lab accreditation with the most recent full report. Missing records from Kaylee Goncalves' U of I file. Missing records from Kaylee Goncalves' U of I file. Documentation appears to be missing from what we have been provided. Letter from Olivia Goncalves, missing pages. See page number 14,004. What the hell is that? That's extremely interesting. My God. Interesting. I don't remember. I don't remember. I wonder what this letter is for. Interesting. Complete recordings from Mary Ann Kohberger's contacts with all law enforcement, including state and local police and the FBI, including direct interviews and any recordings and all transcripts made. Complete recordings from Amanda Kohberger's contact, unredacted and redacted. Interesting. So they're not giving information for what these are. They're just giving page numbers. Number 236 is unredacted and redacted pages 15,221 through 15,248. Numerically missing from sequence. Oh, these pages in general are just missing. Oh my God, this thing is stupid. These pages in general are missing. Interesting. Okay. So it shows that 6,050 through 6105, they only received redacted copies. For 8153 through 8169, they only received redacted copies. There's photos they only received redacted versions of. All the linked and media subfolders in this AV00304 was empty, so empty discovery. Number 241, copies of all 3D scans and photographs completed by the FBI and ISP during their visit to 1122 King Road on October 31st through November 1st, 2023, to include all scans and photographs of the residents and surrounding area. Updated complete cast report. Cast report provided to defense was labeled draft dated 7/10/23 and included no expert analysis. Yeah, that remained an issue for like a long time. All materials relied on or referenced in creating the cast report. This request includes, but is not limited to, FBI Special Agent, there he is, Nicholas Valance's documentation, notes, reports, and copies of materials used in this should probably say in his investigation and analysis. Copies of investigative reports, lab reports, photographs, chain of custody records, and or any other documents that exist related to the analysis of soil recovered from a shovel found inside Mr. Kohberger's vehicle. We've looked through those reports. Copies of investigative reports, lab reports, photographs, chain of custody records, and or any other documentation related to the collection and analysis of soil recovered from 6 different sites in Moscow, Pullman area. Yeah, we looked at that report too. Affidavit in support of T-Mobile search warrant. Copy of records referenced in Moscow Police Report 250, authored by Corporal Payne. What is that? Let's see what it is. Let's see what Report 250 is. Okay. Dog impound form, ISP.3D in LAS format. On Tuesday, November 14th, Detective Sergeant Gilbertson from ISP provided me with a thumb drive of the .3D scans from 1122 King Road. I booked the thumb drive into MPD evidence the same day. On the same date, I received an email from Deputy Olson from LCSO, Latell County Sheriff's Office, containing an attachment of the dog impound form 11/13/22. I printed this copy and booked it into MPD evidence the same day. That's that pink paper that I showed you guys before. And it says copy of records referenced. So, I mean, I guess she's asking for both. The stuff for the dog and the 3D scans of the house. Number 240, copies of all mapping data collected by FBI, SA Nick Balance, and SI Sean Kennedy. See, some of these names, they're okay to put in here, but the other ones, they act crazy. I don't understand. During all drive testing conducted between November 16th, 2022 and January 6th, 2023, this includes, but is not limited to, any and all mapping from Moscow, Idaho, areas south of Moscow, Idaho, Pullman, Washington, and areas south of Pullman, Washington. Number 249, all data, including mapping data, notes, and reports for any drive testing conducted after January 6, 2023. Number 250, copies of all training and certification records for FBI, SA Balance, and Sean Kennedy related to their use of the Gladiator autonomous receiver. Number 251, copies of the collaboration record of the Gladiator autonomous receiver. I remember them talking about that in court. 252, all case communication and correspondence for case number 4870. That's the one that has Talbot's name all over it, and the majority of it is Showalter and a couple others. The basis for this request is as follows. On Bates stamped pages 014364 to 014408, there were only ISPFS LMS reports of case correspondence listed in the communication log for 4843. Since this case was cross-linked to an additional case number, which is 4870, we request all case communication and correspondence for lab case 4870. And again, all of those records are over here in the drive for you guys to look at. We have a couple of them that have unredacted reports, but not all of them. Not yet, anyway. Okay, missing case communication and correspondence for 4843. The basis for this request is as follows. There were several blank areas in the communication log provided. On Bates stamped page 014338, there is one email log entry by analyst Haley Youngling that describes multiple emails sent in efforts to coordinate APHIS search submissions with DHS, DOJ, and California DOJ. These emails have not been provided in discovery material received by the defense. Number 2, the email associated with Bates stamped page 143366 is missing. The log report states that there was an email type entry dated 11/16/22 from analyst Tina Wathall to forensic lab manager Rylene Nowlin. The entry has a notation to see an attached email. However, the rest of the page was blank, and it was followed by another log entry on page 14367 concerning an email exchange between Jade Miller and Bill Thompson that was followed by that email exchange. Email associated with the page 143366 communication log entry is missing. Okay. On Bates stamped page 143364, an email type entry is dated 11/16/22 from analyst Jade Miller to forensic lab manager Riley Nowlin. However, the rest of the page is blank. Can I move myself back where I was now? Okay. On Bates stamped page 143367, there is a blank area under the log entry. On Bates stamped page 143377, there's a blank area under the log entry. Same thing for 143398 and 3404. Number 254, full file system FFS extraction for Bethany Funk's cell phone. Advanced logical extraction only is what was previously provided to the defense. Native phone extraction for Dylan Mortenson's cell phone. The defense has only previously been provided an Axiom report generated by law enforcement. We are seeking the data used to produce this report. Full file system FFS extraction for Eric Gower's cell phone. Advanced logical extraction only is what was previously provided to the defense. Same thing for Kaylee Goncalves' phone after, oh wait, hold on a minute, maybe not. Full file system FS extraction for Kaylee Goncalves' phone after it has been unlocked. The defense has been provided an extraction with user data encrypted due to the phone being locked. There is additional information stored in an unencrypted area on the phone that has not been provided. Please let us know what the current status of the phone is and if steps are being taken to unlock the device. So in big old March 17th, 2025, 3 months before the plea, they still hadn't been able to unlock Kaylee's damn phone. Is that for real? Is that seriously what they're saying in this right now? Like, I knew that there was an issue, but I could have sworn that it had already been handled. So in March of 2025, they still had a problem. That's insane. All reports, information, and data, including all experts, the state has relied upon in developing the affidavits in support of all warrants. Oh, we've seen this formatting before, them just basically saying that we've given you everything you've asked for. Okay. Here we go. This is what we wanted right here. This is an answer. This is some answers. Again, this is as of March 17th, 2025. Okay. When it comes to the 1112 audio, this is such a big deal. Like, it's not even funny. Detective Mowry is currently in the process of manually extracting all audio and video available from the 1112 King Road. The state has been advised this is a lengthy process. The state will provide this information to the defense when it is available. When it is available, meaning in a big old March 2025, you still didn't have it. By way of explanation, there are two data sets for the videos. One original data extraction from the SD card image, but that didn't work. So when did they go back and get the SD card then? Because the first time around did not work. And two, videos downloaded from the camera after seizure of the device. No, that's not it either. No, there's like over a dozen copies of this thing. There is over a dozen copies of this thing. Everything in all of the reports from the 13th through the 19th were failures in trying to get this data. So they're not even mentioning the fact that the actual original data extraction came from Mowry's cell phone. We know that as a fact. We went over the damn reports. What the hell is this? The forensic software used to extract the video from the SD card resulted in no audio, i.e., this is where the missing 2 hours is located. We are currently working to find software that can parse this data with the audio. Regarding the audio for 12:55 hours on 11/13, this is related to a file name in the screenshot 11/17/22/2. This video was extracted from the original SD card image using DVR examiner forensic software, and as explained above, no audio was extracted. Until software is located that can parse the data with audio, we cannot produce the audio. So then how did you hear barking in your timeline? I hate this case. What? So they're admitting that there's no audio, while the damn timeline that they produced over to the prosecution says that they hear barking and people, what seems like people calling for Murphy right before the freaking 227 timeline. Like, I'm glad this information's in here because it proves there's no audio from what we were given. And like I said, Xana's mom sent me her actual, to the Dropbox website itself, not, oh, I'm going to send you my copy of anything. No, she sent me her, actual link straight to it. I downloaded it like I'm her and opened it, and no, there was no audio. So they weren't just sending us a muted-ass version and then the families were getting the real thing. No, the families were getting what we were paying for, which was bullshit. All except for the Goncalveses, because they apparently have their own copy and have since the night of the 13th. Oh my God. Okay. Complete copy of SD card from 11/12. This was provided to the defense on the hard drive provided on 4/5/23. Surveillance camera footage from Latah County Courtroom, 10/26 hearing. This should be on next week's hard drive. Follow up on investigation related to Shannon Gray Media Resources. The state has requested ISP Supplement 199 and will discover upon receipt. Well, which one's that one? Let me go open that real quick. Supplement 199. Let's see. So number 199 is Darren Gilbertson. During September of 2023, the Latell County Court received emails alleging violations. I asked for this. I took this information and I FOIA'd this information right here. Everything in this report about there being grand jury violation with the Goncalveses running their mouths about hearing things and blah, 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 whatever. We know from the book that Patterson had grand jury people information. We also know from the conversation that we have read and gone through millions of times and will continue until the end of time between Steve Goncalves and Brett Norton that he straight up tells Brett Norton that the Patterson guy or whatever got them in contact with 2 grand jury members and that they said that they didn't understand how Dylan wasn't facing charges, that everything about them was extremely sketchy. We already knew that they were having these conversations. So I FOIA'd this information. I wanted the screenshot from the Facebook page that was sent over. They told me I couldn't have it. Or was it that it didn't exist? Let me go back and look. Let me check my emails. Because I asked for this and they either denied me or told me that it didn't exist. It was one of the two. Let me check my email real quick. Damn, this thing is moving so slow. Grand jury violation. I sent it to both. I sent it to both. Let's see. So for MPD, yeah, so I took ISP report 199 written by Gilbertson refers to information being received in September of 2023 regarding grand jury rules being in violation. And I basically copy and pasted the entire report. And then on April 17th, 2026, and I'm going to have all these added over to the spreadsheet and to the Google Drive here soon. I'm working on trying to get everything organized. For this information, it says the statutory exemptions asserted herein shall not constitute a waiver. No, that's not it. Where is it? Hold on. Okay, the city's examination of records indicates that the contents are exempt from public disclosure because the records are prohibited from disclosure under grand jury proceeding rules. So even though it's someone saying that the grand jury rules were violated, and I'm wanting the screenshots that were sent into the police department that says that the stuff was being violated, they're not giving me like any of it. So basically, I guess it sort of means that like it exists, but we're not allowed to have it. Did I ever? Okay, yeah. And when I asked ISP for like the exact same thing because this is an ISP report. Right? An ISP report from Gilbertson. The Idaho State Police has no responsive records. As noted on the last sentence of supplement number 199 of the ISP investigative report, all emails and attached screenshots were provided to the Moscow Police Department to enter into evidence. So they're acting like they don't have their own copy of it, and Moscow PD will not let me have it. I'll do a video about that separately. But I sure tried to get this information, guys, because we know it's true. Like, we know it's true. So I don't know why they're not just letting us have the damn documents. Like, we know that it's a real thing. He was out here on public TV, like, literally gloating about having information from the grand jury all over News Nation. Like, let's be so serious. Why can't we have it? Why can't we have it? Stupid. Okay. Identity of all certified CastViz users within the Moscow Police Department. And it's Lawrence Mowry and Andrew Fox. Andrew Fox is the one that took the like the separate sections of 1112 and like put them all together. There was like over 14,000 little individual clips, and he pushed them down to like 17 individual clips or something like that. CASVIS logs showing the date and time when Officer Mowry examined the records as he documents in his 5/3/23 supplemental report. And then it says the state has been advised that CASVIS does not produce logs. I remember them having that argument. Exhibits created by Mowry while using the CASVIS program. This is Exhibit 48 provided to the grand jury documents from the court on July 3rd, 2023. So then it says any information from the AT&T Hemisphere program, and it says the state has been advised that these records do not exist. For AT&T specific records, when it comes to any information regarding his old phone number and inquiries about, what is this? All inquiries made by any person, entity, governmental agency, or internal software program pertaining to the AT&T phone number. So they wanted information on everybody who's requested information. Like they wanted to FOIA the FOIA, basically, when it comes to this section. And then it says, this is Exhibit 47 provided to the grand jury. And then it shows other things they've also handed over for that. All materials relied upon by Corporal Brett Payne in his affidavit for the search warrant to AT&T. State has provided everything in its possession. The state has been advised that the FBI relied upon the search warrant returned from AT&T to provide additional information to Corporal Payne for his affidavit. The state will need to request emails in the FBI's possession via the 2E process. Remember, we talked about all this stuff. It sure is bringing back a lot of information that I remember them discussing, that's for sure. All information, documents, and data related to the mobile advertiser identification number. We have been informed that the FBI will produce this item in redacted form to protect unrelated parties to the investigation. The only made inquiry was to cobwebs for devices around the crime scene address on 11/22 and 11/20 and around 11/12 and 11/13. No devices of interest resulted from the search. No devices of interest. Okay. The state will produce the redacted form upon receipt. Then when it comes to corrective action log, as indicated by Riley Nallen's emails, that would be available electronically. They were supposed to give them to them the week after. Audit reports. The state has requested these items and will discover upon receipts. Lab accreditation requested and will discover upon receipt. Interesting. Missing records for Kaylee Goncalves for U of I. Documentation appears to be missing from what we've been provided. Letter from Olivia Goncalves, missing pages. The University of Idaho has advised that this item does not exist. They have no record of the previous page in their system. So is it just one page? Is it multiple pages? What is this letter? I don't understand. I want to know more about what that is. Okay, so then complete recordings with Bryan Kohberger. More was going to be over the next week. The defense was previously provided the grand jury transcripts, and then information was discovered back in December of 2023. When it comes to Amanda Kohberger's information, it says that they were going to be getting it to them the next week. So it says that 15/20/21 and 15/20/48 and all those in between that were missing. It says this item does not exist. Defense was provided Bates 15221-15248 on 11/15/23 and downloaded the same day. Those pages are marked created in error. Okay. 6050 to 6105. All these redacted all of these pages where they only had redacted versions and not any unredacted pure versions, they were going to be getting the next week. Whatever was supposed to be in this AV file that's completely empty with all these subfolders that are completely empty. It says the state does not have this item in its possession. MPD received these subfolders from Facebook empty. Okay. Copies of the 3D scans of photographs completed by the FBI and ISP during their visit to 11/22 on October 31st through November 1st. The state believes AV000843 contains the 3D scans. However, it requires proprietary software, which the state does not have, in order to review. Why does everything always take something special? Why does everything always take something special to be able to view? That is so stupid. Updated and complete cast report. The state has been advised that this item exists in draft form, and the final report is pending peer review. All material relied on or referenced in creating the cast report. Let's see. State has been advised that the FBI relied upon records obtained for the 8458 phone obtained via the search warrant, the drive test data, and the tower list data. Item 251 and the tower list have been requested and will be disclosed upon receipt. So the defense didn't even have the tower list information come March 2025. So the search warrant, the drive test data was given over to the defense, but item 251, which is the tower list, no, item 251 is separate than the tower list. So there was the tower list and another item that as of March 2025 had not been handed over to the defense. That's really interesting considering when Ashley Jennings mentioned something about a third tower and got reprimanded by Judge Hippler. Was that hearing where she said that before or after March 17th, 2025? I'll have to go back and find out. That's interesting. Copies of investigative reports, lab reports, photographs, chain of custody records, and or any other documents that exist related to the soil from the shovel. They would be getting them next week. Same thing when it comes to the analysis. They'd be getting them the next week. Affidavit in support of T-Mobile. Search warrant. They're giving them numbers where everything apparently is. Looks like both the files from report number 250 regarding the 3D scans and the dog stuff was sent over in December of 2023. Copies of all mapping data collected by FBI SA Balance. This request includes, but is not limited to, all the stuff south. Discovered May of 2023. All data, including mapping data, discovered May 2023. Training certificates for the federal agents, and it says the state doesn't have custody or control of these records. And then it says the FBI has informed the state that such records demands for training materials are routinely made and routinely denied. Of course, the FBI doesn't want to prove they can actually do anything. We already know better. When it comes to Gladiator Autonomous Receiver, the state has requested these items from the FBI and will hand them over when they have them. Case correspondence for 4870. The state has requested these items from ISP and will discover upon receipt. And again, those are in the Google Drive. Missing case communication correspondence from 4843 with all the blank pages. So for the one for Haley Younglin, they've requested it and they'll give it when they got it. For the one with Tina Walthall and Riley Nowlin, for 143366, it says it does not exist. And that 14365 contains an email from Riley Nowlin to several lab staff members, including Tina, that appears to correspond with it. So it's not like a personal one-on-one email. It's like multiple. On 143364 for Jade Miller to Riley Nowlin and it being blank, it says it does not exist. But on 14365, it looks like it's the same thing. It's like the email that was sent off to multiple people seems to be the one that they think that they're referencing. Because all of them are like, oh no, it's like this next page over. 143367 blank area. They're saying it doesn't exist. But that 14367 through 369 are emails between Jade Miller and Bill Thompson that appear to correspond with the log entry. Same thing for this one. It doesn't exist. That they need to clarify because 143377 doesn't exist. When it comes to 143398, they're claiming again that it doesn't exist. It looks like they're just adding an additional number. 1, 2, 3, 4, 5, 6 digits on the request. And it looks like the actual pages in question here are in the 5 digits, so they're just making a mistake somewhere. Bates 14398 references an email with Jeff Talbot. 1439 contains an email between Riley Nowlin and Jeff Talbot that appears to coincide with the entry on page 14398. It is interesting that they are now telling us a little bit of information but it still doesn't really correlate much. I mean, it does, but it doesn't. It seems like the specifics are still a little bit askew. That's why I'm glad we have this document, because hopefully we'll be able to put some more information together for what the email might actually say, because I don't think that we have the actual verbiage of the emails yet. Not that I've seen. Not that I've seen. The most information in way of there being an issue that I've read correspondence for is for item 108, which is between ISP and the feds for the oral swab that was taken after he got back to Latah County. So it is different. We're going to have to look into that separately. And then it says for 143404 that it's wrong again. 14404 references discovery. 14405 and 14406 appear to be discovery packet printed for the grand jury. And then it says for Bethany Funk's phone, advanced logical extraction was the only extraction completed on the phone, as the full file extraction process was not available in-house at the time MPD extracted the phone. So does that mean they don't have an actual full file extraction for Bethany Funk's phone? They do not have a full file extraction for Bethany Funk's phone. Is that what that means? Welcome, Andy. Welcome, welcome, welcome. Okay. Native phone extraction for Dylan Mortenson's cell phone. The phone data was extracted using Magnet Axiom instead of Celebrite UFED. Isn't Magnet Axiom the data leak program that Hippler stated was used for the information that got out? Because isn't that the one that Celebrate said that they signed an affidavit or whatever saying that they didn't have access to this? Didn't they say that it was Magnet Axiom? I think that's the one. Advanced logical extraction, quick image.zip, was the only extraction completed on the phone, as the full file extraction process was not available with in-house forensic software at MPD at the time. To assist with data examination, Axiom Quick Image has been parsed by UFED and provided as AV file 000A52, which should be available on next week's hard drive. So they didn't have a full file extraction of Dylan's freaking phone either. By March of 2025, by 3 months before the freaking plea, they didn't have a full file extraction of Dylan Mortenson's freaking phone. Oh my freaking Jeebus, bro. Same thing with Eric Gower. Full file extraction process not available in-house. Oh my freaking God. No, incorrect. The front door face north, right? North. Oh no, you are right. Northeast, southwest. No, you're right. So the west bedroom would be Xana's. Yeah, you're right. That's insane. How the hell did they not do this? And again, on top of this, they still have a locked phone for Kaylee. How the hell do all of her freaking family members, how do Steve, Christy, Olivia, nobody knows Kaylee's freaking digits to unlock her phone? Again, we are in March 2025. No full file extraction for the surviving roommates. No full file extraction for Eric Gower. And nothing from Kaylee's phone because they can't unlock it. How does the FBI not know how to jailbreak an iPhone? What is going on? MPD is still waiting on updates and or support from forensic software providers that will hopefully allow extraction of Kaylee Goncalves' phone. Big old March 2025. Big old March 23 months before the plea. I'm floored. That's crazy. Thank you for the gifted membership, Joe Mom. I appreciate that. Congrats to the person who got that. And thank you for the $4.99, Green Girl. I appreciate that. Thank you so much. Isn't it? Isn't it? None of her family knew her code. They're on the same phone plan. There are 13-year-olds that learn how to hack shit that can jailbreak an iPhone. The feds can't. How do they not have full extractions of Dylan and Bethany's phones? I don't understand. After all this time, and guys, there's reports of them sending the phones off to stuff, off to different places to have extractions done. Where's all of that? Because, yeah, cool if MPD didn't have it available in-house. Cool. Within like a few days, they were outsourcing everything. Okay? So if we have read reports of those phones went to like, I don't even know how many locations. There's one report that lays out, and most of you guys will probably remember this. There's one report that lays out the phones being sent off somewhere. I don't think it was all the phones, but a few of the phones got sent off somewhere. And by the time Mallory went to go, or I don't remember if it was actually Mallory because he is the electronic guy, but there was like another person involved in the in-between here because somehow or another, when the person went to go check on the phones had already been removed from that other location and sent to 2 other locations before the original person ever even tracked where the shit was because nobody could get anything done and they kept having to just pass it on to the next agency and the guy had to track it down. We read this in the reports. This is so beyond unorganized and ridiculous. I don't even understand. This is so stupid. This is so stupid. Okay. My God. All reports, information, and data, including all experts the state has relied upon in developing the affidavits in support of all warrants. The state has provided everything in its possession or control that is required by Idaho Criminal Rule 16 to be disclosed. The state will continue to supplement its discovery responses as additional information is received. Okay, so here is some courtroom model exhibit. So is this for the stupid dollhouse? This is for the stupid ass dollhouse. And of course it's upside down. Not like upside down, but it starts down here. Okay, so this is from Ashley Jennings to Ann Taylor. And it says, on March 13th, 2025, discovery is ready. There is a hard drive ready for you to pick up. This includes the information you requested regarding the house model, information regarding the geospatial digital elevation model. We initially had issues downloading this information, but have since worked these issues out. CVs for the team involved. Separately, it also includes unredacted copies of these Bates pages. You should have already received the redacted copies. Let me know if you have any questions or concerns. And then Ashley Jennings to Ann Taylor again. And it says, Ann, we would like to use, okay, so this was before that. Okay, so this is February 3rd, 2025. Okay, so February 3rd, 2025, Ashley sends an email to Ann Taylor, and Ann doesn't see it to respond until March 17th, 2025, a month and a half later. Okay, Ann, we would like to use a 2-scale. That's crazy. So originally they said they wanted to use a 2-scale 3D model, but remember what they said in court? That it was not to scale? They wanted us to know that it was not to scale. So they originally were going to do it right, but because they had issues, they couldn't do it. Of course. We would like to use a 2-scale 3D model of the residence at trial. We anticipate this will be on wheels and each of the residence's floors will detach. I have included a picture of the model. Would you stipulate to the entry of the model? We intend to file a motion with the court for its use. Thanks, Ashley. And again, a month and a half, practically a month, 2 weeks later, she responds and says, "Hi, Ashley. I'm surprised to see this email. I did not see this 3D model drawing in Discovery, nor did I see it in expert disclosures. I need a lot more information and I need to see this in person, likely with an expert. I cannot stipulate, especially without full discovery and expert opinion. Please provide all materials as well as when and where the model is available for our viewing. Thanks, Anne." And then the one that we read first was on March 13th, 2025. Okay, so on February 3rd, Ashley sends the original question to Anne about how they feel about it, I guess. March 13th. This is out of order. This is so stupid, okay? So this is saying this includes the information you requested regarding the house model, and it's March 13th, 2025. But then on March, where's the freaking date? On March 17th, 4 days later, Anne is responding back to Ashley like she's confused about a 3D model even existing. So how 4 days before she actually responds to Ashley, is she asking for information on something that 4 days later she's acting like she didn't know about? Does that make sense? That's a little out of order and odd. So is she just saying, hey, this is the information that you were asking for just so that she could get her attention? That's weird. That's weird, bro. Damn, there's a lot of information in this one right here. These 26 pages were wild. Holy shit. That was wild. Okay. So now let's go to 1, 2. There's 4 left on here because we've already looked at this one for the 7th motion to compel. And this batch of these right here, we already have in the Google Drive and we've reviewed them already. So there's no reason to review them again. So we have 4 left. And this is exhibits 1, 2, and 3 in support of objection to state's motion in limine regarding the AT&T timing advance records. Okay, so email chain between law enforcement, Ashley Jennings, and Special Agent Nick Balance, AT&T search warrants, and AT&T mobility carrier request form. So let's, oh God. Okay. Let me check how they're going in. So this is 11/15/22 at 4:25 p.m. And now down here is November 15th at 4:03 p.m. So yeah, they're going to be backwards. So let's start from here. I know I've got to be in the way. I'm glad I looked. Go over here. Okay. This is as big as I can get it for you guys to be able to see it because of the way that the page is. Thought I had to sneeze. Okay. So November 13th, 2022 at 6:29 p.m. So the evening of. Let's see. Detective Lawrence. The requested time frame for the tower dump is too broad. Please narrow down the requested time frame requested on the form and resubmit for processing. Hello, after speaking with one of your helpful LE specialists, please accept the following exigent form. for review and processing for tower dump of towers providing coverage to this location, the geolocation, for 1122 King Road for 12 hours prior to and following the incident time of 11/13/22 at 4 a.m. If there's any concerns or questions, please feel free. And the response was that it's too broad. Okay. So then they responded back, hello again. Thank you for your quick response regarding this extingent circumstance tower dump. I was wondering if it would be possible to request the timing advanced area search for these records, for all records and unique device user identifiers pertaining to timing advanced location information during the previously listed dates, times, and geographical boundaries. This information was not included in the tower dump records provided. If I need to provide another request form, affidavit, or other documentation, please let me know. And that's Detective Mallory sending that over to T-Mobile. And then it says, from Ashley Jennings to Mallory on November 15th at 1:01 p.m. regarding AT&T tower dump. And it says, how's this look? So I guess there was like an attachment that we don't get to see. And then from Lawrence Mallory to Nicholas Balance on November 15th, 2022 at 4:03, it says AT&T for review. Do we need to use Nellos instead of advanced chiming, or is AT generic enough for use? Okay, so then Nick Balance said to Lawrence Mallory on November 15th, 2022 at 3:10 p.m. Let's see. Nellos became location database of record, or LOCDBOR, a little while back. List that and timing advance, since both are applicable with them now. So this is basically Nick Balance and Mallory going back and forth so that Balance could help Mallory figure out what wording to use for the search warrant. And then it shows that Lawrence Mallory then sent an email to Ashley Jennings on 11/15 at 4:25. And it says, Ashley, AT&T has specific verbiage that used to be Nellos, but apparently they changed it to LOCDBOR. Can we add that to the advanced timing section? I got the attached back from Nick Nick FBI with his recommendation. So yeah, there's definitely this attachment right here, this AT&T tower dump PDF that we don't have access to see here, but maybe it's down here somewhere. Let's see if they have anything attached to this. So this is the unredacted search warrant and order authorizing installation and or use of PIN registered trap and trace device. And this is for Kohberger's phone, the 8458 phone, from June 23rd, 2022 to present. But we've seen this one. Let's just see what they hid from us. Yeah, December 23rd, 2022. Okay, but where's the, okay. Between November 12th, November 14th, 2022. Okay. AT&T mobility carrier request form. And it shows it was being requested by the feds. Let's see if I can make this bigger. Yeah. Salt Lake City office. Tracking number, date 12/24/22. See this? So this is AT&T. And instead of it being from MPD, it's coming in from the FBI. Cy Footlick at FBI.gov. Oh, Seth Footlick. Footlick is the person of contact here. So I'm guessing that's Special Agent Seth Footlick. Criminal court order, new activation, telephone, text messaging, cell site location, packet data, Wi-Fi, call detail records with cell site location, PC, MD, true call, Nellos, RTT, subscriber info, So this person right here, Seth, is requesting it, but it's saying to send all of the information to Nick Balance instead of back to the person who requested it. Non-disclosure order included past 7 days of timing advance data as available. Please include cellular analysis survey team Special Agent Sean Kennedy, as well as Special Agent Nicholas Balance and Anthony Vega as additional contacts. So this was being sent to all these people. Look at this. Brendan Wilson, Eric Fellins, Ken Watson, Seth Footlick, Robert Wilson, Brian Woodall, Karen Capson, Michael Cohn, Mandy Fellins. So I'm going to assume either married or siblings. And then Jeremy Nielsen. Those must be all feds that were helping like look at stuff. Is this the exact same thing? Yeah, this is like all the same. Order. Interesting. Okay. Okay, so now we have defendant's objection to state's motion in limine for the self-authenticating records. This one is 14 pages. Is it going to be a list? Okay. Now, this one is interesting. I don't really want to go through this entire thing because we've seen everything that came out after it. I just want to see if there's any like additional information because this is where we were getting information that it was only Ethan's DoorDash info. And then suddenly it was Xana's. And they originally said they didn't have anything from Xana. And we got a receipt with the time and the address on it. And we were told that it was from Ethan's account. So when we got the stuff from MPD and it came from Xana's account, apparently, and it was all the freaking same, like I still want answers for why we were told that in these court filings. I want answers for the bullshit. I really do. So then we have number one being 1320 Linda Lane and then 1330 Linda Lane. These surveillance videos contained in this folder are 2 videos from the same viewpoint. They're each 1 hour time block. Counsel has located discovery video footage from the 2 cameras that are between 8 and 9 gigabytes of data. This data runs in numerous clips of varying length with an approximate total of 12 and a half hours. The state has not provided any specifics related to what it intends to rely on or use as evidence, nor a certificate that the videos was made and kept in the course of a regularly conducted business activity. So then we have the Albertsons footage, no certification for this footage establishing criteria. The criteria required exists. Amazon financial and user records for Kohberger. Excel spreadsheet with information and categories for subscription information, order history for an Amazon account, Mr. Kohberger and his family members. Contains Mr. Kohberger's father account records and purchase history. The records list purchases for the entire family. Contains subscription history, click activity, and sign-in history for the Amazon account for Mr. Kohberger and his family. Then we have a police report from Michael Douglas. Mr. Kohberger objects specifically to AB 832 as it is a police report, and the prosecution must have a witness to testify about the contents of a police report. He objects to the rest of the requested documents because the records are not a complete record. The court should consider Mr. Kohberger's motion to exclude all Amazon records and expert testimony in conjunction with the state's request. On March 12, 2025, the state filed expert opinions related to Amazon records some 3 months after its expert disclosure deadline. What does this mean? A police report from Michael Douglas. A police report about what? Interesting. AT&T phone records. We know that they were going back and forth with all of that stuff. Bagel shop video. No portions the state intends to use. Giant file. Bank of America records for Bethany, Funk, and Xana. There's additional records for another person. Sections of the record are redacted and blocked out information. Now, they ran financial records for Lakeland, so I wonder if that's the other person. Banner bank records for EC, which is Ethan Chapin, but we need to also remember that BB card for Emily Allant sending $14 via Venmo to Xana. BB was most likely Banner Bank, so we have Emily and Ethan both with the same bank. This would be Banner Bank records for Ethan and his mom. Yeah, we went through that stuff. Cafe Arista contains still photos as well as multiple files of recordings. The total amount of video footage available is around 2 hours. The state has not disclosed what portion of this video it intends to use. Corner Club surveillance video, financial records, Costco, DeSales records for Kohberger. Yeah, they were trying to figure out how DeSales really gave over their information. Apparently there were some issues there. Dick's Sporting Goods. I think they ended up removing that. So that's another thing. They ended up removing so much of the stuff that they did search warrants for when it came to the financial records. They ended up removing so much of it. I think I even made a list somewhere and compared the search warrants they actually submitted and the original information they claimed in the self-authenticating records they were going to keep versus what it ended up being at the very end. Early warning records, Elon financial records for Kaylee, ENS service, surveillance dates for this Pullman, Washington resident. Oh yeah, that's the stuff coming back in. Floyd's cannabis they didn't use. ForestStacksCrypto.com for Bryan Kohberger. Grub truck surveillance video, Harbor Freight video. Yeah, there was so much of this that they didn't even bother using anymore. Other service, Numerica Bank, PayPal, PNC records. DoorDash wasn't even on here, was it? Oh, yeah, right here. DoorDash records for, yeah, this is we've seen pretty much all this already. DoorDash records for Xana and Ethan contains Ethan's DoorDash records, but does not contain records for Xana. But in telling us that they only had Ethan's records and no records for Xana, we got that first DoorDash receipt that had the damn geolocation that when we put it in on the map pinned it right there where the sliding back door was. That gave us the damn 3:59 drop-off time. They literally gave us that while telling us they did not have any of Xana's records. So how? I don't understand the stupidity. I really just don't. I really just don't. But yeah, we went through these lists extensively when they were going through the motions of limine and stuff. And a lot of the stuff when it came to financial records and receipts, going through all of this is how we found out that Kohberger was never in the same place at the same time as any of them. There was one instance of, I think, him and Bethany being at the same target on the same day, but so many freaking hours apart that it didn't even matter. And I think that was literally it. Mr. Kohberger provides as and Exhibit A copy of the federal grand jury subpoena he was provided inadvertently. He sought all grand jury subpoenas through discovery and motion to compel. He was not provided copies other than this inadvertently produced copy of interest, and in support of his objection to the state's motion in that record were dual produced by search warrant and by subpoena. The copy of records is not identical in every production. Why wouldn't it be? This exhibit depicts a letter from FBI agent Douglas directing the keeper of business records to contact him prior to fulfilling the subpoena. What? So if you get a request for this, before you fulfill that request, you better give me a call. That's shady. In the packet in the exhibit, there is an affidavit of compliance which specifies what documents are responsive to the subpoena and specify what it supplied. As has been pointed out within the list discovery items above, when the affidavit has been produced in relation to the FBI grand jury subpoena, there is usually a discrepancy. Mr. Kohberger urges the court to first require the state to explain how each of these records are relevant because the mass production without specificity makes it impossible for Mr. Kohberger to effectively confront this evidence. The court must require verification of the records and videos produced along with any certification. Mr. Kohberger's objection to the state's broad request is summed up with reliance on his rights and protections under the United States Constitution and the State of Idaho Constitution. Mr. Kohberger has protections of a fair trial, effective assistance of counsel, and confronting evidence produced against him. Idaho rules of evidence govern evidence admissibility at trial. Mr. Kohberger objects to the state's request that is a large sweep with a free pass of inadmissibility. The state's request is premature, excessively broad, and must be denied until the request can be disclosed specifically and properly litigated. Yeah, that whole going back and forth with those was definitely interesting. So this next one is regarding the 911 call. Now, we also need to remember when it came to the transcripts, the information that was actually accepted to be used at trial, it was the defense's version of the 911 call. And remember, we went through all of this stuff when it came to the excited utterances and everything that they were trying to claim when they said certain things at certain times, that it was actually a portion of excited utterance instead of it being something they could actually like use against anyone or something like that. What I don't really quite understand is why we have this redaction. I guess it's because it's part of grand jury testimony. But this is court stuff being unsealed. So why are we getting one? Why are we getting one like that? 911 call. The state correctly recognizes the statements on the 911 call are hearsay. Can you make that bigger? Yeah. Idaho rules of evidence make hearsay is inadmissible unless it meets with an exception. The state identifies two exceptions to the rule against hearsay and further recognizes all parts of the statement must meet the exception. The state must provide foundation for an excited utterance. The state alleges that statements fall within the excited utterances or present tense impression exceptions to the hearsay rule or are non-testimonial. The state distinguishes and identifies only one statement, but claims the rest of the statements fall within the exception of present sense impression. The two requirements for excited utterance is 1, an occurrence or event sufficiently startled to render inoperative the normal reflective thought process of an observer, and 2, the statement of the declarant must have been a spontaneous reaction to the occurrence or event and not the result of reflective thought. And remember, the entire argument was, but they waited 8 hours to make the 911 call, therefore everything could technically be a result of reflective thought because they waited 8 hours. It can't be excited utterances because they were aware of the situation before they started speaking about the situation. So that just really doesn't work. That was the argument. This 911 call did not come at 4:30 in the morning when Dylan and Bethany communicated with each other and ended up in the same bedroom. This 911 call came 8 hours later. This call came after Dylan and Bethany each made calls, corresponded through text and other messages to family and friends. The 911 call came only after friends arrived. Bethany initiated the 911 call, and thereafter the phone was passed from person to person. The state lays out only one statement as an excited utterance. The statements of Emily when the phone was passed to her, except it wasn't Emily, it was Josie. It was Josie. Oh, and they saw some man in their house last night. Again, that was Josie. The state claims these words are an excited utterance because they explain why Xana was passed out. The state fails to take into account why that statement was made. The same transcript and same page reflect the dispatcher asking exactly what was going on. Again, it says Emily, but we know that's not correct. Josie stated, one of the roommates who's passed out and she was drunk last night and she's not waking up. Either Bethany or Dylan said, "No, we saw." After that prompted Josie told dispatch about the man they saw. Thereafter, the phone was handed back to Dylan. No, it was handed back to Bethany first. Something else happened, and then Dylan ended up taking the phone after that. The statements by EA. See, this also tells me right here that Chris Whitcomb must have gotten his information for the 911 call from this document, because he's got the same wrong info in the book. Like, we know better, but this is literally the same mistakes that he has in the book. So that's interesting. Okay. The statements by Josie do not fit within excited utterance exception. She first states she is reporting a roommate who is passed out from drinking and not waking up. She then states they saw some man in their house. Josie does not have firsthand information and is repeating what Dylan and Bethany told her. All of the statements made by Dylan and Bethany must be analyzed under the applicable framework for excited utterances. In Mr. Kohberger's response to the state's motion in limine regarding text messages and testimony, he objects in part based on completeness of the record, but also because a more complete record weighs against the state's motion. The phone activity of the Dylan and Bethany shows the statements on the 911 call are not an excited utterance. The phone activity is more extensive than a few messages between Dylan and Bethany. Phone activity did not stop once they were together. It did not begin right before 911 was called, meaning it went on all night. There was no lingering. There was no stopping. There was no halting. It did not magically start up 8 hours later after a complete void of movement and activity. It happened all night long, right up until the 911 call. The 911 call was not contemporaneous with Dylan and Bethany's stated awareness of something happening in their house. 8 hours passed until they called for friends to come to the residence. An excited utterance is a statement that is made while under the influence of an event. The 911 call, the statements contained herein, came after conversation, calls, text, internet surfing, and other phone activity. Present sense impression. The state claims most of the statements in the 911 call meet the present sense impression exception to the hearsay rule. The state says this is so because they all saw Xana unresponsive and were told to call 911. Idaho Rule of Evidence 8031, present sense impression, a statement describing or explaining an event or condition made while or immediately after the declarant perceived it. The only possible statement that qualify for those regarding Xana being unresponsive, except all these people were looking right at her, saw that her bare naked legs were covered in blood, that her face was covered in blood, her hair was covered in blood, her sweater was covered in blood, she was laying in blood, the floor was covered in blood, and still no one mentions blood. And can you imagine the iron-rich smell walking down that hallway after 8 hours? The body smells from what releases when the body dies, also mixing in and sitting there for 8 hours. Could you imagine that? And still no one mentions that shit. Not even in the damn background. Not even in the background. Not even on accident. Crazy. The only possible statements that qualify are those regarding Xana being unresponsive. Statements regarding what Dylan and Bethany claim they saw 8 hours earlier are not contemporaneous in time. Reviewing the grand jury testimony shows the state misplaces reliance on at least some of the statements about Xana. The state ignores previous sworn testimony when it claims the 911 call contains present sense impression because the declarants were observing Xana. And I'm, again, only assuming this is still redacted because it's part of the grand jury information. Fingers crossed, guys. One day, bro. One freaking day. The state has not identified what exception to the rule against hearsay apply to which statements, with the exception of the previously discussed statement. Review of the record and background show neither exception applies. The state relies on the conclusion reached by Judge in denying Mr. Kohberger's motion to dismiss the grand jury indictment. Mr. Kohberger disagrees with the conclusion and the state's reliance on the findings. Judge's findings do not include a full analysis of the applicable exception accompanied by the background information. The court is not bound by judge's ruling. The law of the case doctrine applies where I always end up saying that wrong at first, where an appellate court pronounces a principle of law necessary to the decision. The court has discretion to hear and decide the issues presented before the court. The court, as the trial court, discretion to change its own pretrial rulings, especially evidentiary rulings. Confrontation. The 911 call contains little that fits within the exception of the rule against hearsay. The statement that they saw a man in the house are testimonial in nature. Witnesses will need to be in court to testify to satisfy the constitutionally protected area of confrontation. Transcript. Mr. Kohberger raises the same objections to the transcript being admitted. If the transcript is admitted, and court should only admit a version that is certified by a court reporter. Mr. Kohberger has a certified transcript prepared and provides it as an exhibit to this motion for use should the court allow the transcript be admitted. Mr. Kohberger objects to the state's motion and urges the court to deny it. Testimony in open court and subject to the adversarial process best protects Mr. Kohberger's constitutional rights. Except y'all got like a lot of information hella freaking wrong in this little thing right here. Like a lot of it wrong. Okay. Give me just 1 second, guys. Okay. We are on our last one when it comes to the 404B evidence. Oh, there was a lot of information in these. Still have a few missing reports, but I'm glad we got to add a few. Okay, so defendant's objection to state's notice of intent to use the 404B evidence. Now, right here, okay, this is the only reason, and this is what made me so mad about Judge Hippler, because Judge Hippler literally in court, and I think maybe it was in a document for the order, I can't remember exactly, but he tried to say that the 404B evidence had like more meaning than what the state had for its actual intentions. And part of the 404B rules that we went over when we actually pulled up the code and went through the actual rules for this is that the full intent for why the state wants to use it has to be presented. So if they were going to try to say that he was in that area late at night because he was scoping out the area and was looking for girls or stalking people or blah, 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 whatever. They had to say that. And it wasn't their intention. They weren't trying to say that he was stalking, surveilling, that he was using it for planning. None of that. It was literally for demographics. The defendant's identity, the vehicle, his address, and his phone number. That's it. That's the only reason that why it was being added. And again, they hid that damn traffic stop for this entire time, acting like it was going to be some big, huge, like, kaboom when we finally got it. And the only kaboom there was that their officer is a little liar. Kohberger was the only honest person in that entire video. That's what they didn't want us to know. That's what they didn't want us to know. So it says, argument for this one, the state misconstrues the identity aspect of Rule 404B because the August 21st, 2022 traffic stop bears no resemblance to the crime charged and should be excluded from evidence. When the state presented the video of a traffic stop on August 21st, 2022, and the corresponding citation as evidence to the grand jury, a limiting instruction was given stating this evidence is blank. So, of course, we can't see it. The state misconstrues the identity aspect. Evidence of prior misconduct is relevant on the issue of identity when the evidence demonstrates sufficiently similar as well as distinctive characteristics or patterns between the prior misconduct and the charged crime. When the other act's evidence is introduced to prove identity, as proposed by the state in this case, the characteristics of the other crime or act must be sufficiently distinctive to warrant an inference that the person who committed the act also has committed the offense at issue. Neither the video of a traffic stop on August 21st, 2022, nor the corresponding citation are similar to the charged offense of murder. And then it says conviction was reversed in this United States versus Schramm case from 2018, where video and audio evidence of a defendant's prior encounters with police was offered to prove identity, and admission of such evidence prejudiced defendant's substantial rights. So even though they were only using it for identification purposes, it's still something that is with the police. It's still him getting pulled over. It's him getting a ticket, blah, 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 whatever. So technically, they were okay with having the traffic citation to prove whatever the state wanted to prove. But when it came to stealing a cell phone and selling it, they didn't want to use that at all. I just find their behavior so opposite of what they should have been doing. But it seems like the state was doing more for Kohberger than Ann was. I mean, it's very strange, honestly. The state has other ways to prove Mr. Kohberger's identity without using a prior bad act, which is true. But again, he was apparently speeding. He tells the cop the speed he was going. And then the cop asks if he was wearing a seatbelt. And he is honest and says, no, that he was not wearing a seatbelt. So even though the officer says, well, I actually didn't notice if you had a seatbelt on or not, but because we're doing this like incentive for seatbelts, even though I didn't see you not wearing your seatbelt and you were honest with me about not having it on, I'm not going to give you a speeding ticket. I'm going to give you a seatbelt ticket. Which, cool. Okay. Kohberger didn't pay it. He didn't go to court for it. I don't think so. And it was only like for $10. So a lot of people were like, oh my God, he did him a favor because speeding tickets go on your insurance, blah, 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 whatever. That's not the damn point. It doesn't matter. The point was the officer admitted he did not see if Kohberger was wearing a damn seatbelt or not. And he gave him a ticket for something that he did not witness himself. If that would have gone to court and that officer would have gotten on the stand, that body cam would have come up and it would have been completely just taken off completely, because he would have had to have gotten on the stand and admitted again that he did not see it, that he gave a ticket, a citation for something that he did not witness. You can't do that. So no, it doesn't matter. Oh, it was only $10. It wasn't going to go. I don't give a shit. That's not the point. It's the principle. That's why Kohberger literally asked him, so you don't take into consideration when people are honest with you? Because he was testing him. It became a social experiment. for him right then and there. I actually kind of like wonder if he had his seatbelt on and he just told the cop no to see what the cop would do. Because with the way that his academics were, I feel like that's something that Kohberger would probably do, just based off of the little bit that we know from this case. Cop had no problem lying about something small to get to his little seatbelt ticket quota. That's what it was. That's what it was. Okay, Rule 404B excludes the reference to the August 21st, 2022 traffic stop as evidence in this case. Evidence of a crime, wrong, or other act is not admissible to prove a person's character in order to show that on a particular occasion the person acted in accordance with character. Permitted uses of other crimes, wrongs, or acts is when the evidence is being used for another purpose, such as proving motive, opportunity, intent, preparation, plan, knowledge, identity, absence of mistake, or lack of accident. This is all the stuff that we read about. Then we were like, okay, well, they're not saying that it's motive, intent, preparation, planning, any of those things. The prejudicial effect of character evidence is that it induces the jury to believe the accused is more likely to have committed the crime on trial because he is a man of criminal character. Character evidence, therefore, takes the jury away from their primary consideration of the guilt or innocence of the particular crime at trial. But could you imagine the jury watching that video in court and then them hearing the police officer lie and the man sitting there at the defendant table being the only honest person in that video? Could you imagine the jury reaction? I mean, if this would have actually gone to court and the jury would have done the right thing and reacted to this the way normal people would, then I wonder if the news would have paid attention. Only then, when it's put in front of the actual world, this cop lying and Kohberger being the honest one, is that when the truth would be what News Nation talks about? Or would they still continue to pretend like he's so creepy in that video? It's so shocking, and all their stupid little buzzwords that they use. The fake story put around that Latah County traffic stop is so gross. It is so gross, especially with like Coffin Dagger. She goes around and has always talked about that one and the one from October like it's the most disturbing piece of psychological evidence out there. Crazy ass lady. Crazy ass freaking lady. Okay. Admissibility of misconduct evidence is subject to two-tiered analysis. First, the court must determine that the evidence is relevant to a material and disputed issue concerning the crime charged. Second, the court must determine that the probative value of the evidence is outweighed by the danger of unfair prejudice to the defendant. Rules 401, 402, 403 exclude the traffic stop evidence as irrelevant and unfairly prejudicial. In addition to exclusion under Rule 404B, any reference to the video and citation related to the August 21st, 2022 traffic stop must be excluded as not relevant to the allegations in this case. To be admissible, evidence must be relevant. IRE 402, evidence is relevant if A, it has any tendency to make a fact more or less probable than it would be without the evidence, and B, the fact is of consequence in determining the action. Whether a fact is of consequence or material is determined by its relationship to legal theories presented by the parties. In this case, evidence that Mr. Kohberger was stopped for a traffic violation on August 21st, 2022 is not reasonably tied to crime charged and must be excluded from evidence as irrelevant and not material to the crimes charged in this case. Under IRE 403, this court may exclude character evidence if its probative value is substantially outweighed by a danger of one or more of the following: unfair prejudice, confusing the issues, misleading the jury, undue delay, wasting time, or needlessly presenting cumulative evidence. IRE 403. This rule requires the court to balance the probative value of the evidence against the danger that the evidence may be unfairly prejudicial. Even assuming this court concludes that the character evidence discussed in the state's 404B notice is somehow relevant, whatever minimal probative value it may have is substantially outweighed by the danger of unfair prejudice and confusion of the issues. Unfair prejudice is prejudice that tends to suggest a decision on an improper basis. The character evidence identified in the state's 404B notice has no nexus to the criminal charges against Mr. Kohberger. This evidence confuses the issues. If the video and corresponding citation for the traffic violation on August 21st, 2022 is presented to the jury might well believe that Mr. Kohberger is guilty of the crimes charged because he is a person prone to wrongful behavior. I don't think so, because he's going to be asked a question and he's going to say, no, he wasn't wearing a seatbelt. I don't think that's at all what they would see. As a consequence, there is a danger that the jury would reach a decision on an improper basis due to evidence that is unfairly prejudicial. I call bullshit on this one just completely anyway, because it's a traffic ticket. I mean, everybody at one point is probably gets pulled over for speeding in their life, at least once. Okay, at least once. So for someone on a jury to jump straight from, oh, he was going 6 miles over the speed limit to quadruple homicide, that's a really far stretch. That's some really crazy shit. So I don't really know. Plus, again, he's honest in that video. So I don't know. I feel like the state had more to worry about, for sure, than the defense did in that situation. That's just my opinion. Admission of irrelevant evidence violates due process. Admission of irrelevant character evidence violates due process and can render a trial fundamentally unfair. The rule against the use of character evidence to show conformance with or propensity is a historically grounded rule of evidence. The evidence here is even more remote to the alleged criminal conduct than that described in McKinney. The possession and use of a knife by the appellant in the context of his mother's homicide is another case, completely different case. There is no permissible inference that could be drawn from the character evidence identified in the state's 404B notice, and therefore admission would violate Mr. Kohberger's due process right to a fair trial. Based on the foregoing reasons, Mr. Kohberger respectfully requests that this court issue an order denying the introduction and admission of the state's proposed 404B evidence. And it's crazy because at the time that we were arguing this stuff, we didn't know what it was. We hadn't got the chance to see it yet. We didn't know how harmless it was. We didn't realize that the cop was the one that looked bad at the time we were reading through all of these documents. That's crazy as hell. All right, you guys. That's a lot of info. Super lot of info. It's all there in the Google Drive. Super a lot of info. 9 male DNAs swabbed, never admitted, and tested against any of the unknown male DNA. No full file downloads of Dylan and Bethany's phones by 3 months prior to the plea. And 3 months prior to the plea, they still had not unlocked Kaylee's phone. So did they ever unlock Kaylee's phone? I don't remember now. Like, I need to go and check on that. We're going to have to do a live where we just go through all of the damn phone information. Because there's several reports of those phones going back and forth and having work done. We're going to have to do like a folder for just all the device stuff. Oh my God. A lot of interesting information in these tonight. That's for sure. Crazy stuff. All right, you guys. It is almost 12:30 in the morning. I will be live tomorrow. We'll probably go live twice tomorrow, twice on Sunday. For sure, one of the lives on Sunday will be going through the WSU document. hearing on Monday and Zoom audio only. So we'll get all that figured out. I'll clip out some of the pieces from today that were really important. Like I said, when it came to the certain one where we were discussing lab items that were being swabbed and they were talking about exhibit numbers. When I clip that out, I'll put the photos in there from the 1/20/26 drop of those really graphic crime scene photos that we finally got, because that has most of the exhibit numbers in there. Oh my God. 9. And he straight up says, these could be answers. And they're not, they didn't run them. My God. No wonder it's taking them 6 months. No wonder it's taking them 6 months just to release the next batch of files. It's the last date they opened. Like, how much longer do we have before it's the next year? Because I think we're just March. And they have 2 from February 24th, 2025. So we still have the rest of February and January for 2025 to do, which they'll probably wait another few months before they release those. Did y'all hear that? He's playing his video game. He's so loud. He must have opened his door. We just read through every single document that was released. And I didn't see that name in these, unless it's somewhere else. 51 docs left in the 3rd batch after today's filings that we don't have. Holy shit. Oh, man. It's a lot of information. I'll have to sit down and figure out how to separate it all out without having to do too much over, besides enter more receipts and stuff. Damn. The FBI, Homeland Security, ISP, MPD, multiple federal offices, because Pennsylvania also got involved, on top of all the experts, and no one could unlock Kaylee's phone, and they still never had a full file extraction of not just Dylan and Bethany, but also Eric Gower, very specifically. Crazy. Crazy. All right, you guys. I'm going to go play some Forza race car game. My son was watching some videos on it the other day on YouTube, and I was like, it kind of looks like Need for Speed. I was a Need for Speed freak. You heard me? Need for Speed freak. So it sort of looks like Need for Speed, except Need for Speed is like brighter, prettier. Forza seems like it's more, I guess I try to stay realistic with colors, but I love race car games. And it's a big file, so it took some hours. That's another reason why we went late, because we wanted to make sure that it was downloaded all the way. But now we're going to go play. And I need to after tonight, because damn, that was a lot of information. Oh my God, it's a lot of info. All right, you guys. Thank you again for being in here. Thank you for the super stickers and the super chats, the gifted memberships, and those who joined on their own. I very much appreciate it. Thank you so much. And Miller Time, thank you. I got your PayPal. I didn't see you. Did you just come in here? I also wasn't paying very much attention to the chat. When I'm going through the documents, I try to to read through them and not get distracted so much, or else I'll totally just get completely just distracted all over the place. My God. So if I don't answer a lot in chat and don't see a lot in chat and, you know, a long time goes by, it's because I'm really just trying to keep my ADHD ass paying attention and not losing my spot, because it's taken me some minutes before to find out where I was. And it was just really frustrating. So I try to pay attention. Oh my God. Yeah, I'm going to play some video games. I need a brain break. Oh my God. I will see you guys tomorrow. Y'all have a super fantabulous night. Try to get some sleep. Relax. See y'all. If you like the way that I present this information and give my opinion, please don't forget to leave a like on the way out. Subscribe to the channel if you have not subscribed already. And please don't forget to make sure that the notification bell is set to all so you don't miss any of my rants, reviews, reactions, updates, or deep dives.